Yes.
May I permit to mention regarding item number 162, extremely urgent matter, my lord. 31st, my lord, take over the possession of the enemy property, my lord. I challenge the enemy property act.
162.
162, my lord.
We'll take up on Monday. Monday we'll take up order for 10 matter. Monday to Taito.
Only kindly, my lord.
Monday order for 10 matter.
My lord, kindly to fix the time, my lord. Otherwise, my lord,
We'll take up all order for 10 matters on Monday. We'll reach all order. Please hand over the stick.
May I have a lordship?
Yes, may I permit to mention one WPLT matter?
Oh, so sorry. Well, I'm praying for your lordship's leave to file an appeal without certified copy. Order was uploaded yesterday.
Yes.
There's some urgency in the matter. Section 9.
If the file comes, it will be given.
Grateful.
listed motion for inclusion in
Yes.
Yes, may I permit to mention WPLT matter for inclusion? Your Lordship, affidavits have been exchanged in the month of February. Since then, the matter has not been listed.
What is the year of the?
Your Lordship, 2025.
Please wait for some time. Not right now. Yes.
You permitted to mention a matter. I seek leave to file an appeal without the certified copy.
Yes. Yes.
My lord, in this matter,
Yes.
my lord, on last Friday, my lord had directed us in this matter to file notes of arguments. It was not directed to be
Original side.
original side, my lord. But the officers, I believe, are not present, my lord.
So you can give it to the officer, my court's officer, if you can arrange to give it, so that they can send it to us. Or you just file it. Yes.
Okay.
The hearing was concluded.
Hearing was concluded, my lord. There was
You have
one
to file within 1 week.
one week today. Last Friday it was completed.
তাহলে আমার চেম্বারে পাঠিয়ে দিন। ফাইলটা চলে গেছে। হ্যাঁ? অঙ্কুরকে দিয়ে দিতে পারেন, না চেম্বারে পাঠিয়ে দিন। চেম্বারে আমার ফাইল আছে, পল্লবকে বলে দেবেন আমার ফাইলটা চেম্বারে আছে, ওখানে দিন।
My lord, in the order there was a small error. The matter, there were two appeals. One from the eviction decree, one from the mean profit decree. The number is
Now
erroneous.
can't do anything. It's not in a list. We are not taking the matter now.
Lordship, may I permit to mention one matter. Before the matter I mentioned, I'm taking unconditional apology, Your Lordship. The matter is about that we are the tenant. We lost the matter in Munsef Court. Then we it was a junior division.
Under which heading are you mentioning?
For admission in second appeal, Your Lordship.
This is hand over. Order for right, order for 2. Order for 10. Just write order for 10, rule 11. Yes, call on the list.
Item number 1.
Yes. What is the matter?
Actually, I am not in this matter.
No, we can see who was in the matter.
No, actually, his clerk asked me to mention Your Lordship, my lord. Mr. Manna's matter, my lord.
Yes, that is what we can see. Yes.
Your Lordship kindly adjourn it for 15 days for arranging the matter.
So let it go out of the list whenever you arrange, mention it. In view of the demise of the learned advocate for the petitioner, let the matter go out of the list with liberty to mention as and when an alternative arrangement is made.
But in regard to 28 and 32 also, same.
When those are
Yes, yes. Fine.
keep somebody, you need not be present, keep somebody, some learned junior, then
Yes.
এটা প্রথমবার আসছে। পাঠিয়ে দেবো নেক্সট উইকে পাঠিয়ে দেবো নাকি? তুমি করো না না appears for the parties at the time of call, let the matter stand adjourned for the day. একবার টাইম
But I'm for the petition.
Private list.
Whether the petitioner has challenged, whether the judgment passed by the
Mr. Chatterjee, you have given a notice to the state.
yes, my lord.
Affidavit of service. Fine. Yes. What is the
My
matter?
lord, the judgment has been passed by the West Bengal Land Reforms and Tenancy Tribunal,
Yes.
my lord, whereby my partners have been annulled. My lord, and there has been direction has been passed. My lord, kindly come to this order. Kindly come to the certified copy, page 40. The subdivisional officer Kakdeep is hereby
Please refer to the
directed.
internal page strategy we are following from the memo. The
Yes, my lord.
certified copy.
Certified copy, my lord. Internal page number.
is appear for the petition. He made an accident, my lord. Therefore, হয়ে গেছে ওটা।
দুই হয়ে গেছে।
এটা 3 চলছে।
কৌতুক নন।
Alfred Port 2, my lord. That's right.
কালকে সোমবার মানে
বাইরে বোর্ডে
internal page 3 of the certified copy the subdivisional officer Kagdeep is hereby directed to annul forthwith the pattas issued in favor of the respondent number 6 to 14 in respect of LR plot number 6892 corresponding RS plot number 6505.
It was a retained land wrongly given to you.
No, my lord. I am in possession of that land since 2004. I made a specific allotment in my petition, my lord, in paragraph number 11. My lord,
Mr. Chatterjee, if it was retained land, whether you were in possession, how you got into possession, we
my lord,
cannot look into that.
my lord,
Retained land, the state does not have the, state does not have the jurisdiction to give a patta.
my lord, we
It's
did,
not state's vested property at all.
my lord, the question is that ex parte order has been passed.
This
And
order expert,
yes, my lord,
you are not, you are given a notice.
by the SDO subsequently, and that's why
Not subsequent. Previously, were not given a notice.
no, my lord. My lord, kindly come to this, my lord. May I read this, my lord?
Let us see from the beginning.
Yes, my lord. The present application has been taken up for final consideration.
Proper service of notice.
But my lord, the actual fact remains, my lord, I was not, my lord. That is the,
This is a finding, we have to go by this.
my lord, may I read it, my lord. Despite proper service of notice, none has appeared on behalf of the private respondents, patta holders, in absence of any representation. So rebuttal from them. The avertments made in the application so far, they are supported by the records remain unchallenged. Learned counsel for the applicant submits that the subject land comprising RS plot number 6509 corresponding to LR plot number 6892 measuring 267 decimal Mauja Shivrampur, JL 13, PS Namkhana, District South 24 Parganas was the subject matter of the proceeding under Section 14T3 of the West Bengal Land Reforms Act 1955, being case number 87 of 1983, and that the said land was retained in its entirety in favor of the Rayat, late Nirapada Maiti. It is further submitted that the vesting order dated 31/1988 passed in the said sealing proceeding clearly demonstrates that the subject plot was not vested and continued to be retained land. Despite such a categorical statutory adjudication, pattas were subsequently issued in favor of the private respondents by a sheer mistake, and the record of rights was wrongly altered, causing serious prejudice to the applicants who are in the lawful heirs and original right. Well, kindly see 87, and now this has been instituted in the year 2000. My lord, application of 2024, my lord. There was a delay to, my lord, thereafter, my lord, kindly come to. It is further submitted that vesting dated 31/88 passed in the said sealing proceeding clearly demonstrate that the subject plot was not vested and continued to be retained. Despite such categorical adjudication, pattas were subsequently issued. 4. The state respondents have not disputed any of the factual assertions made by the applicants. No affidavit or argument has been advanced to contradict the claim that the land in question is retained.
Yes. So
Well,
what is
that-
your answer to this? It was a vested property.
Well,
It was vested, not a vested property, sorry. Retained property, yes.
well,
14P3 exercise was there. Everything was considered by the tribe.
well, even Lordship kindly come to the report filed by the SDO once.
It
BLR.
has been commented upon that he did it mechanically only.
Well,
Just forwarded the report.
kindly
of
come
the
to page 65 once. Well,
Yes. It also did not oppose. 65, yes.
65. This is appearance in connection within compliance order passed by the Honorable West Bengal Land Reforms Tenancy Tribunal, way number suggested pursuant to the judgment passed by the Honorable West Bengal Land Reforms Tenancy Tribunal.
65.
Page 64 and 65, my lord. Now I'm reading from 64. Then I'll,
65.
well, may I go to 65 directly.
So whatever.
Right. Submissions of the status report in connection with way case number.
65.
Reference to the above matter, the undersigned is informing before the Honorable Judicature of the West Bengal Land Reforms Tenancy Tribunal that if, after verifying the available files and relevant documents, we have found the following facts that as per RSOROR the name of the riot in subject land RS plot number 6509 of Mauja Shibrampur, Riot Dongs Rishi Lokhinarun Jiu Thakur Shebayat Nirapodo Maiti. And Pitambor having RS Kotian number 770. It was also found that the name of Rakhal Chandra Mohapatra recorded as the Borgadar over the subject plot measuring 2.67 acres, copy enclosed. That as per KB records, the mother volume, it was found that the subject plot, that is RS plot number 6509, corresponding to LR plot number 6892 was recorded under the Khotian number 1, and the description of the plot is as follows: the Rakhal Mohapatra, Pochattor Ananto Mohapatra, Advaita Mohapatra. These are our names, my lord. And that, as per the available records and current Taylor plot information, it is found that 0.03 acres out of total 2.67 acres of the subject plot is recorded under Khotian number 1. And the rest 2.64 acres of the total land was distributed between respondent number 6 to 14 in the original application, RS case number such and such. So my names were recorded since at the KB stage, since our names were recorded since 1980. So my lord, now Lordship kindly come to this section 49, subsection 2.
Land reforms.
My lord, this is West Bengal Land Reforms Act 1955. My lord.
Yes.
Well, if a revenue officer on his own motion or on application made to him in that behalf after hearing the person with whom the land was settled, and in the case of any subsequent transfer, the transferee as also the person who is for the time being in actual occupation of such land, and after making such inquiry as may be prescribed, if satisfied that settlement of such land was made by mistake or obtained under the provision of this section by practice of fraud, misrepresentation, coercion, or otherwise, or that a transfer of any land has been made in contravention of these provisions of subsection 1A, he may by order in writing annul the settlement of both the settlement and the transfer as may be deemed necessary. Then subsection 4, my lord, any person aggrieved by the order made by subsection 2 may within 30 days from the date of such order prefer an appeal to such authority as the state government may by notification in the official gazette specify, and the order passed by such authority in appeal shall be final.
His patta was not annulled, so he was not bound by the 30 days.
Well,
If an order is passed under 2, subsection 2, annulling a patta, if your patta was annulled, then you would have to come within 30 days. Here it was not annulled.
It was not annulled, but
that's why he approached the BLLR first. This person?
No.
Approach the tribunal first.
Directly. Well, that is the annulment, and well, the seeking the annulment. Well, this is the difference which might have been for. After 18 years of delay, my lord, this has happened, my lord. Kindly see, my lord, here.
So this is not time bound. 49(2) exercise is not time bound. There is no limitation for that. After hearing the person with whom the land was settled, and in the case, transferee. So this may be on own motion or application. So you may say that the application ought to have been filed by them.
Yes.
Before the revenue officer first.
Before the revenue officer
then
first.
Came up the rungs.
That is one aspect, my lord. Even, my lord, the application, my lord, under this application was entertained under section 10 of the West Bengal Land Reforms Tenancy Tribunal Act. And I was reading section 10, my lord, application of tribunal. Here, my lord, there is one requirement that tribunal, if it is satisfied in inquiry, it may deem fit requirements where the application under subsection was been admitted by the tribunal, dispose of the application expeditiously. But, my lord, the first thing, subject to the provisions of section 6 of the provisions of this act, a person aggrieved by the order passed by the authority or the action taken either by the authority or by the state government may prefer an appeal to the tribunal for the redressal of his grievance, my lord, it's an appeal. Every application under subsection 1 shall be made within 60 days from the date of which such order was passed or such action was taken, as the case may be, or within such further time as is allowed the tribunal to cause shown its satisfaction, that shall be made in such save and express provided in this act. The tribunal shall not admit any application referred to subsection 1 unless it is satisfied. One,
Therefore, 60 days would come in.
60 days
At least 60 days would come in.
will come.
First of all, no application directly lay before the tribunal. Secondly, even if it lay before the tribunal, it had to be within 60 days
60
that
days.
order of
Yes.
patta.
So, my lord, there is a requirement also. The application has availed all remedial measure available to him under the relevant specified act. So, my lord, that was not, my lord.
Let's
That is
hear the
my
other side.
submission, my lord.
Yes. Who should you hear for? You for or the state? Yes, Mr. Bhattacharya.
If your lordship kindly consider page 46, the ground for preferring the application before the tribunal.
Yes.
They have approached the tribunal in the non-consideration of the prayer of the applicant to annul the patta of the respondent number 6 to.
But we don't know whether that was made. You say that that's not time bound. But the tribunal itself deciding it, they lose a forum, 2 forums. That's one of the factors we are considering. Undoubtedly, yes.
Instead of passing a mandatory order, the tribunal
Finally
my
disposing of
observation, ought to have referred the matter before the BLR
to the BLR. Yes, sir. What do you say? We'll do that. We'll refer it back to the BLR to consider on merits upon giving them an opportunity.
Grateful, my lord.
Rather, upon giving you an opportunity. It's their application. Thank you. The ambit of the challenge is short. Full stop. The learned West Bengal Land Reforms and Tenancy Tribunal, comma, on an application made by the private respondent, comma, annulled a patta granted to the writ petitioners. Full stop. Next para. While doing so, comma, the learned tribunal went into the merits of the matter, comma, considered materials before it, and came to conclusive findings as to the subject plot being a retained land of the private respondent. Whose next parallel counsel appearing for the petitioners argues that the tribunal ought not to have entertained the application in view of there being a specific forum, that is the revenue officer under section 49 within bracket 2 of the West Bengal Land Reforms Act 1955, comma, designated for taking up an application for annulment of patta. Full stop. Next para. Secondly, comma, the application was made after a long delay from the passing of the order granting patta. Full stop. In any event, comma, it is argued that an application before the tribunal can only be filed after exhausting all the remedy provided in law, and that too, comma, within 60 days of the order. Full stop. Having not done so, comma, it is submitted that the private respondent was not entitled to an order in its favor annulling the patta of the writ petitioners. So next para, learned senior counsel, standing counsel appearing for the state submits, comma, in his usual fairness, comma, that the matter did not came up before the tribunal as a challenge against the grant of patta, but was filed by the private respondent complaining of inaction by the revenue officer within bracket BL and LRO bracket closed in sitting tight over the application for annulment of patta made by the private respondent. Full stop. As such, comma, it is contended that no forum was bypassed by the private respondent. Full stop. Next para. Upon hearing learned counsel for the parties, comma, we find that the petitioners are justified in arguing that section 49 within bracket 2 specifically provides the revenue officer as the designated statutory forum to annul pattas, comma, either on its own motion or on an application made in that behalf. Full stop. In the event the private respondent was aggrieved by the inaction of the BL and LRO in disposing of his application for annulment, comma, the appropriate remedy, comma, as rightly pursued, comma, was to complain of such inaction before the tribunal. Full stop. Next para. However, comma, the learned tribunal overstepped its jurisdiction in conclusively determining the entire dispute on merits without relegating it to the revenue officer himself. Full stop. Next para. Such usurpation of jurisdiction of the designated forum automatically denudes both parties of two forums of challenge, comma, first the appellate forum and thereafter the tribunal. Full stop. Next para. Thus, comma, even without going into the question of limitation, comma, since an application complaining of inaction is not strictly governed by the limitation of 60 days, comma, we cannot lose sight of the fact that the learned tribunal acted without jurisdiction in conclusively determining the matter by usurping the jurisdiction of the revenue officer. Full stop. In such view of the matter, comma, WPLRT 159 of 2026 is allowed on contest, comma, thereby setting aside the impugned judgment dated February 5, 2026, passed by the third bench West Bengal Land Reforms and Tenancy Tribunal in OA 3064 of 2022 bracket LRTT, and remanding the application of the private respondent for annulment of the patta granted in favor of the petitioners to the concerned BL and LRO, that is,
My lord, Shivrampur Nam Kakdeep, my lord.
all right,
Namkhana.
Namkhana.
BL and LRO, comma, that is the BL and LRO Namkhana within bracket respondent number 7 hearing bracket closed for a comprehensive adjudication on merits in accordance with law upon giving adequate opportunity of hearing to all necessary all interested parties, comma, including the private respondents, comma, the writ petitioners as well as the state. Full stop. It is expected that such exercise shall be concluded as early as possible, comma, preferably within 4 months from the date of communication of this order to the respondent number 7. Full stop. While doing so, comma, the respondent number 7 shall not be unnecessarily influenced by any of the observations made herein or by the learned tribunal. Full stop. We make it abundantly clear that the merits of the respective contentions of the parties have not been gone into by this court. Full stop. No orders to cause.
My lord, the question of limitation, my lord, that may be kept open so that it can be argued.
It is made clear that merits have not been gone into, comma, including the question of maintainability and limitation.
Grateful, my lord. Document open as well. Grateful.
Thank you.
Item number 4.
Make please.
Yes, for it. Here for the private state. Oh, here for the state.
Challenging the order of the learned tribunal.
Yes.
This order was passed ex parte, place it. And what happened? The private respondent, number 5, in view of the civil court's order being titled suit number 135 of 1948, approached the BLLRO for correction of record of right. That was not done. Then appeal was preferred. Then that was not done. Then tribunal approached, and then ultimately tribunal direction, and the BLRO corrected accordingly. After correction of the record of right, allegedly, he preferred, rather presented a representation to the BLLRO claiming further correction, not the challenging that order. And that representation was taken into consideration by the tribunal, and an ex parte order was passed.
How did the tribunal take it? He was sitting tight and then they complained of it.
According to like the according. And it was categorically pointed out by the learned government representative who was representing before the tribunal that private respondents are not before you, despite the tribunal proceeded and passed an ex parte order for further correction.
So you say, whatever times the correction has to be done, it has to be given on notice and
not like that. But once
order was challenged,
once the order has been passed by the BLL and LRO, by correcting the record of right, that can be challenged further before the appellate authority.
But this is a further correction they wanted.
But the further correction, once the
Available to them at that point of time.
at that point of time.
Constructive res judicata principle also applies.
This is the case.
Have the private respondent been served properly?
Yes, yes, yes.
No, I'm stated. You have checked up. Sir. Yes, what do you say?
Lordship, kindly see the impugned order, Lordship, first.
Yes.
See, impugned order, page 50, Lordship. Page 50. Tribunal only direction to the authority concerned, Lordship. Page 50, relevant portion, Lordship, page 51. Carefully gone through the all 51 Lordship, gone through the all documents and records. It is quite evident from that the DLNR Dinajpur in the aforesaid appeal case has categorically and unequivocally passed up order upon BLNR Bunsi Dokhin Dinajpur, whereby the LR Khoti and PPR in the name of the respondent number 3 to 8 have been ordered to be cancelled, and it was further ordered to reopen the new LR Khotian in the name of the applicant. And hence we are the consider view that the BLNL Bunsiori Dokhin has got no other option than implement that order. According to the BLR Bunsiori is directed to correct the error pursuant to the order.
So thus, is it according to you that only the private respondent sought an implementation of the earlier order of the DLLR?
Yes.
Sought an implementation of the earlier order whereby DLLR had said that reopen it.
Made a representation before the authority concerned, only praying for consideration of the representation.
So not seeking a further correction, but seeking an implementation
of prayer of the tribunal application, Lordship.
Let us see.
Prayer of the tribunal application.
Yes.
Page, Lordship, 99. Lordship, middle under the above circumstances, your applicant must humbly plead that your Lordship would graciously please to pass an order directing the concerned respondent 3 BLNLR Vasidoni to deal and dispose of the application, representation that is such and such of the applicant by necessary correction as per the order of the.
Let us also see this representation.
My lord.
Once. Where is that representation?
Page 42 it starts.
Wait.
Relevant portion, if your lordship kindly take trouble, page 46 in our page 5. The second paragraph, your lordship will find, my lord. May I once again want to check the service once again? To me, when I am making submission before the court.
All of you are very fair and we know that. That's why we ask you. We never check up.
Internal page 5, second paragraph.
Yes.
Your lordship also looks into the order of the BLLR. It starts from page 87, my lord.
No, but here he refers to at every stage there was an order of the appellate authority. Within the last one, 3 orders of appellate authority are referred to here.
My lord.
So apparently every time appellate authority passed an order.
My lord.
Because the third line from the bottom, 30/1995 appeal case 3 hoite.
This is the main appeal by which this correction was made.
Somosto khতিয়ান delete করার নির্দেশ দেন. Even the revised khতিয়াans also.
My lord, your lordship, kindly have a look at page 87. This is the order and understanding of the BLLR. Order dated 31st January 2024.
Yes. Yes.
Well, may your lordship can look into my lord, if your lordship. Well, page. Sorry, I'm sorry.
No, no, please.
No. Well,
89.
well, page
89 is
88,
irrelevant.
last paragraph, it starts the reasoning.
Yes, we have seen that. Yes.
And
By deleting LR record.
yes. And page 89. Conclusion has been arrived at by the BLLRO. These cannot be reopened.
This should have been challenged.
This should have been challenged. But that has not been challenged straight away to the tribunal. Your lordship 10-3, your lordship knows, your lordship dealt with this particular provision, and your lordship set aside that part of exercise by the tribunal.
This is the last order of the BLLO.
This is the last. No.
He gave a fresh representation, which was not considered, and this.
Yes, lordship, page 89, lordship.
Yes,
Lordship, kindly.
There's an adjudication by the BLLO.
Yes.
Whatever way BLLO has interpreted the order of the appellate authority.
Yes, lordship, in the
After that, without challenging this, how can he file another application?
I know, lordship.
It's like execution is done.
No, lordship, in the representation, as well as pair of the original application, for implementation, the order passed by the BLNR and appellate authority.
He has already, whatever was the perception of the BLLO, he has implemented. This is an implementation order. But if he is aggrieved with it, like suppose the appellate court remands.
Yes.
Trial court passes a decree after remand.
Kindly.
He is aggrieved with that.
He
cannot take out another application saying that no remand order should be implemented. It has not been correctly implemented.
Kindly come to the page number 89.
89, we are there only.
Yes. Lordship, the name of the present petitioner was deleted, Lordship. The other respondents have purchased.
See, thus, the BLR records here, the other respondents have purchased, been gifted through registered instruments and recorded in their respective khotians. Without declaring the registered instruments null and void, by the civil code, this record cannot be considered in favor of the appellant.
Yes.
Shubhendu took the such and such, got this property through inheritance, so it will be recorded in favor of the appellant.
Yes.
So therefore, the appellant was not given certain relief by saying that without declaration of the other registered instruments bad, so a right accrued in their favor, because regarding that portion, it was not deleted. So therefore, this was an interpretation of the BLR of the appellate authority's order. If this was wrong, he should have challenged this, not sought further implement. There cannot be implementation twice. BLR has already complied with the appellate authority's order in his own perception. If it was a wrong compliance, he should have challenged this order.
Yes, Lordship,
the
tribunal not pass any order, effective order, only directing the authority concerned to consider. Nothing else.
Let us come back again.
There's not a direction for considering the representation.
Only consider.
For no. See the last line.
After, yes, according to the BLR, so directed to correct the ROR person to the order after hearing all necessary party. You have 3 months from the date of disposal.
No, initially the appellate authority directed the BLLO to cancel the LR Khotian prepared in the name of respondent was 3 to it them, and further order to reopen new LR Khotian in the name of the applicant. This was the direction, reopen new Khotian. So what would be the extent of that reopening? That was interpreted by the BLLO. Because which regard under section 54 has clearly directed to reopen new Khotian in favor of the appellant by deleting LR record. of the respondent, this order has not been challenged. So this compliance proceeding is maintainable. And then it is ordered that the property recorded in LR Khotiyan such and such will be recorded in favor of the appellant by opening a new Khotiyan. So he complies with it in his perception.
Loss.
Then he says the other respondents have purchased, been gifted the suit property through registered instruments and recorded in their respective Khotiyans. Without declaring those registered instruments null and void, it cannot be done because third party rights have been accrued.
Lossy, one thing, Lossy, kindly come to page 50. 2024 order was not placed before the tribunal. 2024 order was not placed. Lossy, kindly come to page 50. Input order, Lossy.
Yes. 25.
The instant OA is directed against the alleged
Page
inaction
50.
on the part of the BLR of Aswani, Dokkin Dinajpur for the non-implementation order dated 2001, passed by the DLNL Dokkin Dinajpur.
This is the present impugn order. Yes.
But they are 30 of 1995 has been mentioned.
So that tribunal have no knowledge about the order of the 24.
It is their application. It is their application.
But what he is saying, I can't understand.
So that
Please clarify.
The in the year of order dated 31st January 2024, order was not placed before the tribunal by the applicant.
This BLL order was not placed.
No, so kindly see.
That's why it's an erroneous order of the tribunal.
Tribunal only he placed the order in the year of 2001.
Oh,
On that basis, tribunal passed the order.
This chapter was subplaced.
Yes. Then also the peasant petitioner can file an appropriate application before the tribunal to reopen this matter.
He has come up before us saying the tribunal is wrong.
Because they are not made, even if the applicant not made a party then.
They were not made parties.
They are not made party in the tribunal.
That's why we are setting aside this. Oh, no notice was also given to them in that order.
Only
we are
setting
aside the order. Tribunal could not have done this if the private respondents are aggrieved by the order of the BLL of 31st January. They are entitled to prefer a challenge against them, subject to limitation and or condonation of that, because we won't be partisan in their favor.
It's obvious. Service to
The repetition, affidavit of service filed to be kept on record. Despite service, the private respondents are not represented, although the writ petitioners as well as the state are represented through counsel. So next para, the grievance of the petitioners is that the learned tribunal, while considering an application of the private respondents alleging inaction on the part of the concerned BL and LRO in implementing a previous order of the appellate authority, disposed of the matter on merits and directed the BL and LRO to correct the records of rights in terms of the said representation of the private respondents, purportedly in compliance of the appellate authority's order. The next parallel counsel for the writ petitioners points out that after the order of the appellate authority directing reopening of the LR records and recording the names of the private respondents, the matter came up before the concerned BL and LRO, who passed an order on January 31, 2024, implementing the order of the appellate authority. While passing, the BL and LRO recorded that certain properties recorded in the LR Khotiyan would be recorded in favor of the appellant within bracket present private respondents by opening a new Khotiyan. It was, however, further observed that the other respondents had purchased been gifted the suit property through registered instruments and recorded in their respective Khotiyans by producing the registered instruments. It was held that without declaring the registered instruments null and void by the civil court, such records could not be considered in favor of the appellant within bracket present private respondents, bracket closed, and accordingly the said part of the prayer of implementation was turned down. Next para, it is argued that if the private respondents were aggrieved by the order of the BL and LRO dated January 31, 2024, it was open to them to challenge the same before the appellate authority in accordance with law. Full stop. However, the second implementation application, after the BLNLRO had already uh, implemented the order of the appellate authority from its own perception, was not maintainable at all. Full stop. Next para. Learned Counsel appearing for the state points out that apparently the order dated January 31, 2024 passed by the BLNLRO was not brought to the notice of the tribunal. Full stop. However, it is submitted that in the event the present petitioners are aggrieved with the order of the learned tribunal, where no notice was served on the writ petitioners, it is always open to the writ petitioners to approach the tribunal itself for recalling of such order. So, next para. However, upon careful consideration of the arguments of parties, we find that the impugned rights would be directly affected by the said judgment, ought to have been given a notice. Full stop. Next para. Secondly, the learned tribunal overstepped its jurisdiction in directing implementation of the order of the appellate authority a second time, after the BLNLRO had, in terms of the appellate authority's direction, already disposed of the matter by reopening certain LR Khotians with a order dated January 31, 2024. For sub next para, we acknowledge the fact that either of the parties might have been aggrieved by the interpretation of the order of the appellate authority by the concerned BLNLRO in its order dated January 31, 2024. Full stop. However, fact remains that the BLNLRO had decided the matter conclusively in terms of the order of the appellate authority in accordance with the legal perception of the BLNLRO, right or wrong. Full stop. Upon such interpretation of the BLNLRO, the self-same order of the appellate authority could not be sought to be re-implemented, without challenging the order dated January 31, 2024. Full stop. Next para. Accordingly, the remedy of the private respondents did not lie in a fresh application for implementation, which was erroneously allowed by the learned tribunal, but by preferring a challenge to the order dated January 31, 2024. Full stop. Next para. In the light of the above observations, WP LRT 160 of 2026 is allowed on contest, thereby setting aside the impugned order of the
notice. But once your lordship looks into page 38, the BLRO again issued notice. That notice should be cancelled.
So we say all consecution.
And one thing, my learned friend, it will page 109, once your lordship. In the representation, he has categorically mentioned BL and LRO Sahib record সংশোধন করার order দেন। উক্ত অর্ডারের তারিখ 31/1/2024 রেকর্ড সংশোধন হয় এবং আমার নামে এলআর নাম্বার 2538 খোলা হয়।
Let us not give a model for Khanaka. We have
No, my lord.
Order dated, setting aside the impugned order dated October 27, 2025, passed by the third bench, West Bengal Land Reforms and Tenancy Tribunal in OA 2560 of 2025, bracketed LRTT, granting liberty to the private respondents to prefer a properly constituted challenge before the appellate authority in accordance with law against the order dated January 31, 2024, passed by the BL and LRO, Bongshihari, Dakshin Dinajpur in
Page lordship.
No, the miscase, any miscase number or anything?
No.
yes, yes, লসি এর বুঝলাম
নাম্বার নেই
পেজ পেজটা বের করো করা নেই
page 84
Hmm.
there is a your lordship kindly come to page 84, no number has been only it has been referred appellate authorities order.
Very well. তার যেখানে বললাম comma which is annexed at page 87 of the present writ petition, comma subject to limitation and or condonation of the same. Full stop. We make it clear that if any such challenge is preferred, comma, the same will be decided in accordance with law upon giving adequate opportunity of hearing to all interested persons, comma, including the writ petitioners and the state. No orders to cause circumstances. Yes.
Okay. Also, I have purchased a piece of land in the year 2022, my lord, and a record of rights incorporated in my name, my lord.
It's endorsement, no proper service.
My lord, address wrong, my lord. I have served, my lord, in the address they have filed in the original application, my lord.
No. No such person in such address.
One is insufficient address, another is no such person at such address.
Lordship, in the original application, they have given address that
Their application,
Lordship.
before the tribunal.
Lordship.
This address was given.
Lordship.
2022 purchased.
Lordship. Lordship, kindly come to the order, my lord.
No, then what happened? What is the order?
Lordship.
You purchased in 2022. You said
Lordship.
that. Then
Land recorded in my name, my lord. I am in possession, my lord. Now, the privatization number 5 to 20, my lord, they have filed an application before the BLR of Barubit, my lord, for correction of record of rights on the plea that they are predecessor, my lord, interest, my lord, and they are the successor, my lord, on Sabur Ali, my lord. In the CS record of rights, their name appeared as Korfa, my lord, not the maintenance, Korfa. Thereafter, the original Jamidar, my lord, rejected Sabur Ali's name, my lord. Thereafter, new parcels came, and subsequently, that land was several occasions transferred in the name of other parcels, my lord. Now I have purchased, my lord, and I am in possession.
once he was recorded as a court for tenant, how did the Jamindar cancel?
So since they have not paid the rent, my lord, their name ejected, my lord, as per the land and the West Bengal, my lord.
It was subsequently transferred to others also.
Others, my lord.
That was reflected somewhere.
Lordship, may I place that record, my lord?
From the records of right, it was reflected.
Lordship.
Very well.
In the RS record of rights, new name come, my lord, in the name of.
Applied, it was re-recorded in the name of that Sabur Ali.
No, my lord. Initially,
order. What did the BLLR do?
Expeditious disposal.
My prayer for
expeditious disposal.
But fact remains that, my lord,
before us.
Lordship, but fact remains that, my honorable learned tribe, Lordship, learned tribunal directed the BLR on 3 occasions, my lord. Learned tribunal directed the BLR on 3 occasions to place the record, but they have not placed, my lord. And I am suffering, my lord. I cannot use the land, my lord, freely, my lord.
Why is the BLR not placing the records? Where are the directions on the BLR?
Lordship, kindly come.
Yes. 9th of April order.
On 3 occasions, they have directed, my lord. Another thing, my lord, applicant, my lord, has submitted that applicant's name was recorded in the CS and RS record of rights. That is the wrong submission, my lord.
That will not go into the merits now.
Lordship.
So we may direct the BLLR to produce the record sought by the tribunal quickly and the tribunal to decide it.
Within time bound, my lord.
The counsel for the writ petitioner submits that the learned tribunal that the original application of your original application.
Lordship, they have filed. Except 5 and
application is theirs. Way is theirs.
There, my lord.
The original application filed by the private respondents before the tribunal, where the present petitioner is a respondent, has been is being delayed inordinately. For the next para, learned counsel submits that at least on 3 occasions, the learned tribunal directed the concerned BL and LRO That is which respondent?
Barupir, my lord. Respondent number.
That is
Respondent number, my lord.
respondent number 4,
4, my lord.
comma, to furnish a status report along with an authenticated copy of the RS ROR. Full stop. However, comma, the BL and LRO is delaying the same indefinitely, comma, thereby instigating the protraction of the litigation. Full stop. Next para. We find from the affidavit of service and the postal articles submitted before us that although service was sought to be effected on the private respondents at their address as given in their own original application before the tribunal, comma, proper service could not be effected, full stop. We deem it to be good service, comma, full stop. In any event, comma, in view of the innocuous nature of the order proposed by us, no further service is being directed on the private respondent, full stop. Next para, upon hearing learned counsel for the writ petitioner and the learned senior standing counsel, comma, appearing for the state, comma, this court is of the opinion that the respondent number 4, comma, that is the block land and land reforms officer, comma, Baripur, is required to furnish the status report and the extracts of the records of rights as directed by the tribunal before the tribunal as expeditiously as possible, and the tribunal, comma, thereafter, comma, is required to dispose of the matter original application at the earliest. Full stop. Next para. Accordingly, WP LRT 161 of 2026 is disposed of by directing the respondent of 4, that is the block land and land reforms officer, comma, Baripur, to comply with the directions of the tribunal and furnish status reports and as well as copies, extracts of the concerned records of rights before the tribunal at the earliest, comma, preferably within 4 weeks from the date of communication of this order to the respondent number 4. Full stop. The learned tribunal shall, comma, if necessary, by shifting back the next date earlier, comma, take up the original application for hearing and upon giving adequate opportunity of hearing to both sides, comma, to all concerned, comma, dispose of the same as expeditiously as possible, comma, preferably within 6 months thereafter. Full stop. No orders to cause urgency.
Lords, grateful.
Yes.
This is almost same with regard to earlier. My lord, I want, my lord, speedy disposal of the matter pending before the land.
No BLRO direction is there.
No.
No direction.
My lordship, kindly consider page 38 and 39. My lord, their direction to file affidavits, my lord, was given as per the prayer of the private respondent.
It's your original application, Mr. Giri.
My
Private what about service? They have been served properly.
My lord, I have served.
Yes. Served, we have checked up.
My lord, I have checked up, but my lord, one problem is there.
Yes.
My lord, respondent number 6, 7, and 8, 5, 6, and 7.
Yes. What about this?
6. My lord, 4, 5, and 6, they are the, my lord, brothers and sisters. My lord, 2 have received, and in case of another, my lord, it has been written left.
Service have of the OA has been effected on them.
Yes, yes, yes. They have appeared. Page 38.
They have appeared.
Yes.
At the same address.
Yes, yes, yes.
What is the next date fixed by the tribunal?
Next date, my lord, on 10/12/2026. Page 38.
Good. So what is your view of heard learned counsel appearing for the writ petitioners as well as the learned senior standing counsel appearing for the state. Who's up next para? In view of now from the affidavit of service, it transpires that the private respondents, comma, apart from respondent number 6, have been duly served. Full stop. Insofar as respondent number 6 is concerned, comma, learned counsel for the writ petitioner points out that the service was sought to be effected at the address address of the respondent 6 as disclosed in the original application before the tribunal, from which address service was effected, and the respondent number 6 is also appearing before the tribunal. Full stop. Next para. Thus, comma, we deem the same to be good service. Full stop. Even otherwise, comma, in view of the innocuous nature of the proposed order, we do not direct further service on the private respondents. To some next para, since the original application is pending before the learned tribunal since the year 2024, and long dates are being fixed, comma, as evident from the order sheet placed before us, comma, WPLRT number 162 of 2026 is disposed of by requesting the third bench, comma, West Bengal Land Reforms and Tenancy Tribunal to dispose of MA 304/2025 as well as OA 3524 of 2024 bracket LRTT bracket closed pending before the tribunal, comma, as expeditiously as possible, comma, preferably within 6 months from the date of communication of this order to the learned tribunal. First of no orders to cause suggest.
My lord, my learned friend is appearing for respond number 5 and 6. 5, 6, and
5 and 6 or 7?
5, 6 or 7.
All the private respondents.
all the private respondents.
আরে ওই যেখানে বললাম যে ইন এনি ইভেন্ট নো ফার্দার সার্ভিসেস ওইটা কেটে দিন, ওটা কেটে দাও। তার আগে যেখানে শেষ করি, তার আগে সেন্টেন্সটা যেখানে শেষ করেছি যে ওই ডিম টু বি গুড সার্ভিস, যেখানে বললাম যে যেটা কাটতে বললাম তার ঠিক আগের সেন্টেন্সে শেষ হচ্ছিল তো অ্যাকর্ডিংলি ডিম টু বি গুড সার্ভিস বুঝছো, তারপরে একটা লাইন অ্যাড করে ওইটা যেটা কাটতে বললাম সেটা কেটে তার বদলে at this juncture, comma, learned counsel, what is your name, please?
Advocate Somrat Hawk.
Roy.
Hawk, HOK.
Somrat Hawk.
Hawk.
At this juncture, comma, Mr. Somrat Hawk, learned advocate, appears and submits that he has instruction to appear for the private respondents. Full stop. Accordingly, the matter is taken up for hearing. Now it's a matter of your Hawk.
Probably, my lord, this is his maiden appearance before my lord.
So good that his name is recorded in whatever manner. Yes, Mr. Bhattacharya. You're leading him. You're leading him. There's nothing in the matter. Private respondents have been served, proper service effected.
No private.
What is that?
Lord, I have handed up one list of dates. Lord, I'm giving a copy to Mr. Bhattacharya.
Yes.
Also. Lord, kindly have a look to the list of dates once. Purchased the land in the year 1957.
The present, if you order, then we'll go.
Alleged big riot. And it was the allegation of the state authority that particular big riot had not filed any B form under West Bengal Estate Acquisition Act. So they did not consider 6.5. Since that big riot did not come before the authority under 6.1 and retained the particular land
Estate Acquisition
under section 6.1, hence the entire land of the big riot was taken into consideration as vested. Then being the post-vesting purchaser, we went before the authority that you have already mutated our name. Why you have struck off our name without our permission or without our consent or without giving us any hearing? Then they did not do it, anything. Then we went before the LRTT, filed an application. LRTT has asked to consider the authority and consider my mutation application again, though my mutation was done prior to that.
Now you seek a correction of the records of rights.
That's been done. That's been done. It has got a checkered history.
No, mutation in your name, correction in your name.
Yes.
So now that has been changed again.
Yes.
So now you pray for recorrection. So this is also and
previously. First way was concerning that.
Achha.
Thereafter, second way for compliance of the previous way's order.
All right.
Then the tribunal has said since they have vested, then they came up with the vesting order saying that your mutation cannot be done because this land has been vested.
Then tribunal has directed me go before the authority by filing 57B proceedings. We went before the authority by filing that particular application. And in that application, the concerned SDLRO has held, yes, Big Riot, this much of land was in excess because
Ceiling limit.
ceiling limit 6.5 subsection 5 of section 6. If I do not go before the authority within the time specified or stipulated time period,
Authority can choose which part.
authority can choose under subsection 5 of section 6.
Yes.
Then authority passed an order in favor of us. In favor of us. Then authority has directed, in the meantime, interregnum period, in violation of tribunal's order, authority has doled out patta in favor of patta holders. Then another proceedings before the SDO for the annulment of patta.
No, 1 second, Mr. Thor, we missed a link in between. You said the appellate authority, 57B authority said that no, this was retained.
I'm sorry.
That a challenge was preferred against that before the tribunal.
No, I was wrong. Not the appellate authority. Hearing officer, that is the SDLRO. SDLRO has said that big riot.
So then what happened immediately thereafter?
Then the SDLRO has directed you initiate a proceedings for cancellation of patta.
In violation of that, this patta is granted.
Yes, the honorable tribunal's order also
Came before the tribunal against
again, my lord, we went before the authority saying that they are not mutating because they are not complying with the order passed by the SDLRO.
So you sought an implementation of
the SDLRO's order.
PLRO was not doing it, therefore you went to the tribunal.
Again.
Tribunal directed.
Yes.
Directed to consider
third time.
To consider your implementation
Yes.
application.
Representation, and then fourth time again. Fifth again. Then fifth time in 2017 when we went before the tribunal, seeing the compliance report, tribunal has said, very well, compliance is done. So
compliance. How was it compliant?
They have come up with again the same fact that vesting. Then we came before this court. Yes, we came before this court by filing a writ petition, and another coordinate bench passed an order. Please see to that. Set aside the order passed by the tribunal, and thereafter again, tribunal luckily passed a caustic remark against the authority in a contempt proceedings and all. Then state came up with a review petition before the tribunal to consider that caustic remark and everything. So our contempt and the state's review both were disposed of in a common order. Challenging that common order, state came before my lord's court. And my lord has also passed an order directing, yes, challenging my lord's order, they went before the Supreme Court. Their SLP was dismissed. Then again, my lord, the tribunal has held, since both the orders were before High Court, and one was one order of the tribunal was affirmed in toto, that was the language in the judgment, and another review petition which was disposed of by the tribunal got merged with the High Court's order. Hence, the contempt petition is not maintainable before the tribunal.
The review we rejected.
Yes.
And the caustic remarks were set aside.
Yes.
Rightly.
Then again, I had to come before my lord, and my lord has said, yes, go before the tribunal, contempt lies before the tribunal. Because first order was, yes, contempt.
Caustic remarks were set aside, but contempt was alive.
Yes.
So now what happened to the contempt?
Now in the contempt proceedings, when we sought for the recording as also the possession, tribunal said, sorry, go for a recovery of possession under CPC. This is the fact.
You sought an implementation of 57B order, originally 57.
Yes, and the order passed by the SDO. SDO has annulled the patta under subsection 2 of section 49. Now tribunal has directed me, go again, do entire thing. Well,
What
I
was
took the
what was
point of
What was the contempt alleged by you? What did they not do?
recording as also my land was doled out to the patta holders in violation to the
Those were annulled by the SDO.
yes.
So now that has been set aside. Patta has been set aside.
But they are
Recording-
still in occupying the land.
No, what
Patta
was
holders are occupying the
is a
land.
contempt then? Your names ought to have been recorded there.
Name and the possession.
Don't you have to, because if they're in possession, unlawful or otherwise, don't you have to remove them from possession first? Recording of in the records of rights, you can understand,
Well,
but their possession never was never set aside. I mean, possession, they were not evicted at any point. They are still in possession physically. Unlawful possession, but possession.
Well, if original vesting goes,
Unlawful possession, but they are still in possession.
well, kindly see then subsection 3 of section 49. It was the bounden duty of the authority
Yes, to implement.
to implement.
All right. Very well. So let us see the tribunal's order.
Yes.
In the contempt, you wanted to get this 49.3. Can you do that?
Not in a contempt, my lord. Previously, our prayer was there.
The contempt being decided by the. So is it also within the scope of your contempt to argue that it may be or may not be?
Substantial relief, my lord. We have learnt it from my lords that substantial relief can be easily
I have
granted.
learned it from me. I never give substantial. Always partial. Let's see which part we can allow it. So you say
I cannot go before the civil court for eviction.
Court forgets. We understand, but you want to interpret as the original order of correction of the records of right to also include 49.3 sort of.
Yes, I am covered by few judgments which says the honorable division bench
49.3
that
automatic.
once the vesting order is set aside, everything goes. If pillar is fallen, the entire construction goes. I do not require to make patta holders as a party to the proceedings.
Because 3 says when a revenue officer makes an order, the revenue officer shall enforce. So it's automatic.
It's automatic. Even they have the power to requisition the police force.
Yes, yes, that is there. What does it do ultimately? So this is only turning down your prayer for recovery of possession.
Yes.
And contempt is disposed of.
That-
In the contempt, you ask for recovery of possession also. That is beyond the scope of the contempt jurisdiction.
No, no, I would say, my lord, to deliver, to render the complete justice or substantial, my lord, as also the provision says, 2006, the patta was cancelled, annulled. Now,
Why do you give so many dates, Mr. Dhar? It's
my lord, kindly come to
48
15.
dates. Are you substituting 48 dates?
15, serial number 15.
It's
SDLRO.
It starts from your client's birth date. So before that even, probably. Yes, before that. Predecessor in interest. Anyway,
Serial number 15.
15.
SDLRO Kakdeep initiated reference case number 10 of 2004 under section 57B3 of the West Bengal Estate Acquisition Act, and then next one is 18th October 2004. SDLRO Kakdeep disposed of reference case number such and such, allowing intermediary to retain 25 acres, including the subject land, 8.18 acres purchased by the predecessor of petitioners.
Then 2nd March 2005. Then, my lord, kindly straight away come to. Yes, before that, my lord, I would like to show the ADM's order. That is serial number 19, 4th July 2006. ADM DLLRO South 24 Parganas asked BLLRO Namkhana to initiate proceeding under section 49(2) of WBLR Act for annulment of patta. Then 18 February 2010, ADM DLLRO South 24 Parganas issued further letter to BLLRO to take immediate steps to comply with earlier memo and initiate the proceedings for mutation as also the patta annulment. Then 11 November 2010, BLLR submitted report that miscase number 2 of 2010 was drawn up. Tribunal directed SDO Kakdeep to adjudicate proceeding under section 49(2) within 3 months. Then 28th February 2012, SDO Kakdeep initiated case number 2 of 12 of 2012 for annulment of pattas, and SDO Kakdeep annulled all pattas granted vide RS case number such and such and RS case number such and such. So everything, well, I would say, done and dusted. Not only that, well, before the tribunal, we got an interim order. This patta was granted in violation of the tribunal's order. And subsequent to that, there is a GD entry, there is an information to the SP that in violation of this tribunal orders, this patta was granted. '57, 1957 till 2026, 6 times before the tribunal, 4 times before the High Court.
Violation of which order of the tribunal? Pattas were granted in violation
I'll show.
Which order of the tribunal? Pattas were granted from 1997 onwards.
Yes. And tribunal has noted that also.
So how could it be in violation of tribunal's order? Tribunal was formed in 1997 by the 1997 Act.
Yes, kindly come to 112 of my writ petition.
So from the list of dates you show us, which order of the tribunal? This item 9?
No, no, no.
Not to give effect to the settlement.
Item.
No, item
Yes,
7.
that was item 9. Was right. Yes, 7 and 9.
এটা বলো কোনোভাবে আলাদা আলাদা দেওয়া যায় নাকি পেজে টাইপ করা তিনটে রেজিস্টার কন্টেন্ট
May I take your lordships to the exact order passed by the tribunal?
As a consequence of direction was compliance means
May I show the exact order passed by the tribunal and
Yes, we are looking at that.
not the impugned order, the previous round of litigation.
Yes.
Kindly come to page 78 once.
To annex the application for contempt here.
Contempt application is there?
লাগানো আছে শান্তি আছে আমাদের নিচের কোর্টের কন্টেম্পট এখানে লাগানো আছে
Please. Yes. Have annexed.
Yes, yes. Kindly have a look to. I'll take your lordships to the
78.
contempt application as well.
78.
Kindly come to page 78. Status quo with regard to possession of the subject land as of today shall be maintained till the disposal of the representation as directed above. Now, kindly come to the next round of litigation, next page. It has been alleged that although the order was passed by the tribunal to maintain status quo till the disposal of the representation, the BLLRO Namkhana, in violation of the said order, has settled the subject land. BLLRO is directed not to give any effect to the order of the settlement, if any, in respect of the subject land, until further order from the tribunal. Then, they did not do it. 78B, I have notified the concerned police station about this. This is the, I have brought it.
So they gave effect to the order of
Yes,
position.
yes. Then, kindly come to page 80, This has also been notified to the SP of the concerned district. Now, kindly come to the annulment order passed by the SDO, where SDO has heard all the patta holders. They were before the SDO, and SDO has cancelled all the pattas in the year 2006. Page টা বলো 82. Thank you. Kindly come to page 82. Sorry. এটা SGL order 65. Reportটা দেখো. 104. That 104 tribunal's order. Yes, sorry, 108. Kindly come to 108. I'm just placing from the penultimate paragraph of 109. Heard the opposition. I'm sorry, Malad has got it.
Yes.
Heard the opposition party, the Pattadar, settled with the subject land under section 49(1) of the WBLR Act. Learned Council pleaded that OP were never made party to the lawsuit referred by Dijendranath Bhomik, my predecessor, since deceased, and by his legal heirs, the first party of the instant case matter. So the entire matter has been decided beyond their knowledge. Such and such then also placed his argument that such and after hearing the contending parties at length, findings of the undersigned authority recorded as follows: on examination, such and such, then secondly, all the copies of material such and such, then it is evident from the case record that the schedule of land is declared as retained land of the Big Rayat amongst other land which was purchased by Dijendranath Bhomik. This is father of the applicant. So in the light of the order of miss case number 10 of 2004, disposed of under section 57B3, read with section 6(1) and 5, the subject land was treated as retained land of the Big Rayat concerned, and it was necessitated for correction of Arwar, since consequential action of settlement of subject land became infructuous and stands void ab initio. That was the language. But the subject land having been already settled with the Pattadars, the second party, BLLRO Namkhana, felt it prerequisite to initiate proposal for annulment of patta under section 49(2) of WBLR Act with Rule 20B of the WBLR Rule 1965 and referred the case matter to SDO Kaddi for order in order to proceed. Further, for correction of ROR, Court LRTT in his order dated 11th November 2010 in the matter of such and such also passed direction upon the SDO Kaddi to effect the annulment of patta related to the subject land for onward correction of ROR in favor of the applicant. So it was actually the tribunal has directed first you cancel it, then mutate it. But thereafter, what they did not bother to comply with the previous order.
Therefore, there was the specific direction under 49(3).
Yes.
But you say it's a natural corollary of 49(2).
Consequential, my lord.
Now tribunal has said that your name has been corrected.
Yes. Oh, this much is done. Hence, order has been complied with. Hence,
Sorry. রিকভারি করছেন এখন চাইতে পারেন এটাই বলছি রিকভারি করছেন চাইতে পারেন প্রেজেন্টেশন ছিল তারপরে বলছি অলরেডি ইনভিটেশন in the present day, there is no prayer for recovery person rather for mutation application. Mutation application, when you filed it, you were in possession.
No.
That is recorded by the tribunal.
That's because they have a set format for mutation.
Oh.
There is a set format. You can't change it. The tribunal took the advantage of that and my lord, this is on record, my lord. A format will not override the previous all orders. Tribunal's order, tribunal has set status quo. Thereafter, tribunal has noted the violation. Then thereafter, 2006, SDO has passed an 2004 SDLRO passed an order. Then ADM directed the BLLRO, concerned BLLRO to cancel the patta. Thereafter, the tribunal again passed an order directing the SDO to cancel the patta since it was in violation, and also the original vesting was set aside absolutely by the concerned authority, holding that this is a retained land.
The years of Vijendra.
Yes. A format will override all these facts or orders. I'm asking myself.
Let us hear the mistake.
I wanted to rely on few judgments.
If you want to take a seat with you.
দাও পরপর দিতে থাকো
2023
আগে পশুপতিটা দাও, বানেশ্বর জানাটা দাও। পশুপতি দাস I'm relying para 2 99 volume 1 CLJ page 123. 99 volume 1 CLJ page 123. Para 2 9 नहीं तो हटा गया। Here it says even notice is not required upon the patta holders. In my case, it's altogether different facts. Already patta was annulled. Already by the SDO. And ADM has directed on several occasions, please comply with the order.
Yes, yes.
Now, Anand, Here, my lord, I am relying on 456 para. This is vesting under 14T3. Subsequently, patta was granted. 1992, volume 1, CLJ, page 489. Dich. এটাই দিয়ে দেবো আমি তো অসুবিধা para 456. In 6, paragraph 6, in my view, the aforesaid observations of such and such S. Ahmed J have full application in this case. Furthermore, the order by which the lands were treated as vested lands by the state were set aside by the appellate order. Therefore, in the eye of law, there is no determination as to the extent of retention of lands under the Act. Since the order of vesting was set aside, there was no scope to treat the land as vested land to the state of West Bengal. The appellate authority having had set aside the order of vesting, there was no scope to hold that the original order of vesting on the basis of which the lands were settled in favor of the added respondents should still continue. Since the order of vesting was set aside, the right following to the said added respondents from the said order of vesting must automatically come to an end.
Yeah.
2023.
Yeah.
Huh?
Yeah.
Yeah.
Hmm?
2023.
না
এটা নাও কোথেকে নাও
কোনটা
এই উপর থেকে
এটা দেবো
না উপরের থেকে 2023
এটা কেন দেবো এটা লাস্টেরটা
17.3
আরে সাবস্টেনশিয়াল জাস্টিস আর কনসিকুয়েন্সিয়াল সেটা ও
So it is automatic, my lord. If vesting goes, entirety goes. All consequential, everything, my lord. Even if I do not pray for it, এটা দাও and I'll be relying on para 117. Oh, sorry, 2023, 17 SCC, page 545. Para 117.3, although the transfer of the suit property pendentillite may not be termed as void ab initio yet, when the court is looking into such transfers in contempt proceedings, the court can definitely declare such transactions to be void in order to maintain the majesty of law. Apart from punishing the contemner for his contemptuous conduct, the majesty of law may demand that appropriate directions be issued by the court so that any advantage secured as a result of such contemptuous conduct is completely nullified.
Yes.
And the beneficiaries of any contemptuous transaction have no right or locus to be heard in the contempt proceedings on the grounds such and such. That is.
Yes.
Oh.
Don't multiply the judgment answer. You have cited so many judges. Any one what point?
No, this is again in at the time of status quo order. Transfer had taken place, and while taking note of the Honorable Supreme Court has said, whatever you have done, you have changed the record. If you have transferred, whatever you have done, come up with the.
Yes.
Para 5, 6, and 7. and I'll rely mostly on 8. The court makes it clear that if there is any other document executed or acts of omission or commission by the respondents or alleged contemners, which is related or may be relatable to the stay order that dated such and such, the same shall also be withdrawn, reverts to restore the position as was existing prior to such and such. Prior to such and such date, as basically the act relates to one single deed and maybe other deeds relating to all other respondents or alleged containers, one common affidavit would suffice to indicate that all the respondents or alleged containers are party to such purging of the contempt, which shall be filed within 2 weeks from today.
We'll come back and continue.
এটা দাও, এটা আনরিপোর্টেড
I never disturb your lordship in the middle of the matter, but under compelling circumstances, I have to mention, because my lord, I intend to file an appeal challenging an order, my lord, passed in the miscellaneous case. Probate has been granted ex parte. I filed an revocation. In revocation proceeding, an application has been filed under Order 7 Rule 11 that has been allowed. I intend to file an appeal. Yesterday I filed the appeal. Now it appears as defective. Now, my lord, today my junior went there. Now they are saying that in the first page of the order, another case number has been given. Therefore, we will not accept the same, because my lord, citation has been issued according to the petitioner. 3%.
Your number is also there.
My number is if I permit.
No, your number is also there.
My case number is miss case 280 of 2024.
That also appears in the order.
The order impugned is the next one, but the certificate copy which I have obtained, my lord, in the if your lordship kindly see once. I will not disturb your lordship, my lord, kindly pardon me. I have only one copy. But kindly see 269 has been filed by another person.
Yours is 280.
280. In 280, Order 7 Rule 11 has been filed. That has been allowed. So I intend to prefer an appeal.
Yes.
Now the computer is not giving the number. My junior went there. The person might have told that no, then you have to write in the memorandum of appeal that 269 has no connection with this appeal and everything. Then I said I cannot write before this is a certificate copy. They are not giving the number. I cannot file the appeal, my lord.
We'll call the person and stay back. Someone stay back.
Ma'am.
When the person comes, we'll have a talk with you. Yes, Mr. Dhar.
Yes. Well, the next judgment, my lord, I'll be relying on. My lord,
how many judgments in total?
Only 2, 3. I'll not bother, my lord. I have already taken so much time. My lord, kindly come to page. Down. 2024 SCC online SC 3727. Okay, dite hobe to. Para 221 and 222. Before we close this, we may address yet another submission canvas such as 221 and 222, where Boranagar Jute Factory, Musdur versus Boranagar Jute Factory PLC was relied, wherein it was held that the court not only has a duty to issue appropriate directions for remedying or rectifying the things done in violation of its orders, but also have the power to take restitutive measures at any stage of the proceedings. The relevant observations has been quoted, and then 222. Similarly, a three-judge bench of this court in the case of State Bank of India, Dr. Vijay Malla, 2020, in clear terms said that apart from punishing the contemner for his... Yes.
Don't multiply judgment on same.
I'm not.
These are substitute case.
That is it, my lord. I'm not multiplying.
Where is your application
So-
for contempt?
Oh, yes. I'm extremely sorry.
No, it's all right. Sure.
ওই প্রেয়ারটা দেখাও আর কন্টেন্টের প্রেয়ারটা দেখিয়ে দাও
120A page.
120A.
Why I tell you? Because the observations of the tribunal in
There is no
page
prayer.
3, that is troubling us. That
There is no prayer.
2 paragraphs.
Yes.
120A page, original application.
120A.
Page 120H.
120H. এটা কিসের প্রেয়ার? কার? ওয়ের?
হ্যাঁ, ওয়ের।
120H. We'll find.
The prayer of the OA.
Yes, and the prayer of the contempt. কত কত আরো না ঠিক আছে prayer 9 দেখে নিন in OA prayer 9 is there where I have sought for it. Well, my argument is even if I do not.
No, that's true.
Yes. Well, kindly come to page 133. This is the contempt which is annexed, Manat.
Yeah.
And the prayer portion is
146.
146. And DD, one of the judgment, DD skipper is relied that court has the duty to wrong things done to be restituted. Set the wrong back.
There were two contempt applications, MA 1820 and 1682.
No, one contempt, one review.
Let us hear Mr. Bhattacharya.
From reading the application as well as my learned friend's submission, as I understand, the point which is remains to consider that whether the SDO is duty bound to deliver the possession in terms of 49.2 or 49.3 of the West Bengal Land Reforms Act.
Because corrections have already been done.
And secondly, whether
Yes.
the court can expand the scope of the contempt proceeding or not. If your lordship kindly consider, first, the original order that is passed by in the tribunal in this particular proceeding, which is at page 125, it starts from. Relevant portion 132. Second paragraph. The BL and LRO Namkhana District South 24 Pargana is directed to correct the LR record of right with respect to the subject property and to record the names of the applicant accordingly within a period of 2 months from the date of communication of this order. Without fail, the District Land and Land Reforms Officer, South 24 Pargana, being the appropriate authority, is directed to ensure that this order is duly complied with by the BL and LRO Namkhana District South 24 Pargana within a period specified above. So this is, the original order. Now, I'm sorry, can you consider page 120H, the prayer of the original OA? An order directing the respondent number 5 to dispose of the mutation application of the applicant being number such and such. An order directing the respondent number 5 to implement the order passed by the Honorable Tribunal in OA number such and such. That is the order to consider the representation and pass a reasoned order, which was earlier directed by the tribunal. and muted the name of the applicant of the suit plot mentioned in paragraph 6.2 of this application and order directing the respondent, their main and agents, associates, and each of them to certify, transmit records and such orders or further order. So this is the scope of the original application and on the basis of which the order passed, wherein a direction was given to the concerned BL and LRO to correct the record of right. Now kindly see the compliance order, which is at page number 203. And since my learned friend has already shown the prayer made in the contempt application, that too relates to the correction of the record of right. Which is that the contempt application starts from 133 and the order is the prayer is at 146. Now,
correction.
Yes, that is strictly related within the scope of correction of the record of right. Now, this compliance order at page 203. Reference to the above matter, the undersigned is sending here with the compliance report of the solemn order dated 16th of June 2026, passed by the Honorable Land Reforms and Tenancy Tribunal in connection with OA number at such and such. As per the direction of the WP LRTT, white order number such and such, the OA of LRTT proceeding for correction of record of right in the name of the petitioners have been initiated and disposed. The present LR plot information of plot number such and such, Mouja Horipur, jail number 21, are submitted herewith for your kind perusal and ready reference. So direction was specifically for correction of the record of right that was complied with by the concerned BL and LRO. Now, in the said contempt application, my learned friend now praying for possession that has to be handed over by the SDO in terms of order 49, section 49, rule 3. Now, my first point is that in a contempt proceeding, the court cannot expand the jurisdiction of the original order passed in the in that particular proceeding. In this regard, I am relied upon a decision reported in 2007, volume 4, CH.
Give us half a second. Yes.
2007, volume 4, CHN.
Give us a copy.
996.
Give us a copy.
I'm just saying to get it photocopy.
What is the judgment? 2000?
7, volume 4, CHN 996, paragraph 9, 10, and 11.
What does it say?
I'm just handing one. Can you take my copies? I will hand over the photos.
Read out, so that you can.
996. It is now a settled law that while exercising the contempt jurisdiction, the court cannot extend the span of the main order, the violation of which is alleged. In this connection, it will be profitable to refer the following observation of the apex court in the case of V.M. Manohar Prasad versus.
This is a division bench judgment of our court.
Yes. An order passed in the contempt petition could not be a supplemental order to the main order granting relief. Number at paragraph 10. The same view was taken in the earlier judgment of the Supreme Court in the case of Jhareshwar Prasad Pal versus Taraknath Ganguly, reported in 2002, volume 5, SCC 352, where the apex court made the following observation. The purpose of the contempt jurisdiction is to uphold the majesty and dignity of the court of law, since the respect and authority commanded by the court of law are the greatest guarantee to an ordinary citizen, and democratic fabric of the society will suffer if respect for the judiciary is undermined. The Contempt of the Courts Act 1971 has been introduced under the statute for the purpose of securing the feeling of confidence of the people in the general for true and proper administration of justice in the country. The power to punish for contempt of court is a special power vested under the Constitution in the courts of records and also under the statute. The power is special and need to be exercised with care and caution. It should be vised sparingly by the court on being satisfied regarding the true effect of contemptuous conduct. It is to be kept in mind that the court exercising the jurisdiction to punish for contempt does not function as an original or appellate court for determination of the dispute between the parties. The contempt jurisdiction should be confined to the question whether there has been any deliberate disobedience of the order of the court, and if the conduct of the party who is alleged to have committed such disobedience is contemptuous. The court exercising contempt jurisdiction is not entitled to enter into the question which have not been dealt with and decided in the judgment or order, violation of which is alleged by the applicant. The court has to consider the direction issued in the judgment or order and not to consider the question as to what the judgment or order should have contained. At the cost of repetition, be it stated that the court exercising contempt jurisdiction is primarily concerned with the question of contemptuous conduct of the party which is alleged to have committed deliberate in complying with the direction in the judgment or order. If the judgment or order does not contain any specific direction regarding a matter, or if there is ambiguity in the direction issued therein, then it will be better to direct the parties to approach the court which is disposed of the matter for clarification of the order, instead of the court exercising the contempt jurisdiction taking upon itself the power to decide the original proceeding in a manner not dealt with by the court passing the judgment or order. If the limitation is borne in mind, then the criticism are sometimes leveled against the court exercising the contempt of court jurisdiction, that is, that it has exceeded its power in granting substantive relief and issuing a direction regarding the same without proper adjudication of the dispute in its entirety can be avoided. This will also avoid to multiplicity of the proceeding, because the party which is prejudicially affected by the judgment or order passed in the contempt proceeding and granting relief and issuing fresh direction is likely to challenge that order. Malat, I have the 2 copies of the ballot. This.
No, we'll just take photocopies.
Issuing fresh direction is likely to challenge that order that may give rise to another round of litigation arising from a proceeding which is intended to maintain the majesty and image of the court. Judging the case in hand on the touchstone of the principle noted above, we find that the direction issued by the division bench in the impugned judgment, this portion is relating to this particular case. Now, my lord, the paragraph 11. We are therefore unable to consider the question of passing the further direction as paid for in this application, enlarging the relief already granted to the petitioner while disposing of the main mandamus appeal or subsequent application for contempt. So here, my lord, the main petition restricted to the correction of the record of right. The order passed to the extent of correction of the record of right. The compliance that has made to the extent of correction of the record of right. So, my lord, the question of delivery of possession in terms of 49.3, that has not been either addressed before the tribunal, nor it has been prayed for. Now, secondly, 12. And in that case, my lord, what is the course of the action? That is also, my lord, in paragraph 12 of this judgment, if the petitioner is of the view that the alleged action or inaction on the part of the bank on any of the legal or fundamental right has been violated, he is free to approach the appropriate forum in accordance with law. So, after the recording of the names, he is always free to approach the authority under 49.3 for delivery of possession. Now, another point is, if your lordship consider the 49.3 once, this is an independent proceeding. In a contempt proceeding or in a proceeding, the court cannot direct the SDO to deliver the possession because
49.3 is a proceeding.
Why I am saying this? Because 49.4, lordship kindly consider, there is a provision of appeal. 49.4 is
against two.
Just
against 49.2 order.
Yes.
He is a corollary of 2. It's automatic.
Only for the purpose of
no, they are after 49. 49.5 kindly consider, my lord. 49.3a. Well, 3a is there for the purpose of enforcing the delivery of possession of any land and evicting any person in actual occupation.
Continuance of 3.
Now, my lord, kindly. Then, my lord, 4. Any person aggrieved by an order made under subsection 2 within 30 days from the date of such order prefer an appeal before the authority as the state government may by notification.
That was for the persons whose name was recorded.
Recorded, my lord,
were corrected and their name introduced. Those persons to challenge that order under 49.2.
Yes,
Here 49.2 order has been passed.
Here, my lord, the 49.2 order has been passed. Now, my lord, 49.3, so far as that, my lord, my humble prayer is that, so far as the delivery of possession
The
is
initial grievance was that before the tribunal was that 49.2 order was not being passed. Tribunal directed it to be corrected in consonance with 49.2. Their contention before us is, Mr. Bhattacharya, that 49.3 is a natural corollary of 49.2. So if 49.2 is directed, then 49.3 automatically comes in. Because 49.3 says when a revenue officer makes an order under 2, annulling settlement or both settlement transfer, the revenue officer shall enforce delivery of possession of such land. So it's automatic, they say.
Now, my lord, since, my lord, this order of 49.2,
yes,
that this particular 49.3 or 49.3a,
yes,
that part is omitted, that has to be challenged, my lord. Now, my lord, in the contempt proceeding, my lord, when there is a specific, or my lord, that has not been prayed before the tribunal. The delivery of possession, my lord, that has not been paid, or my lord, the point that what has been argued before your lordship, that has not been even pleaded before the tribunal. Only prayer
is saying hold the BLLO guilty for non-compliance.
Compliance for recording.
Recording. Not saying that hold the BLLO guilty of non-compliance of the recording direction. They are saying if recording direction is complied with, a natural corollary would be that this possession should be given. If that be so, the contempt court, even without hauling up the BLLO, because there may have been some dilemma as to whether 43 follows automatically, contempt court itself could reverse whatever advantage was taken of the contumacious order. Now, taking advantage of the delay in correcting the records of rights, these settlements were given, pattas were given, which were even subsequently set aside. So, therefore, when the matter went to the BLLO, he ought to have negated the advantage taken by third persons for the delay. Because the delay in complying with the order by correcting the records resulted in this partas being given and all.
But my humble submission is that since when the tribunal passed an order directing solely restrict himself for the correction of record of right, that part has not been challenged.
No, obviously, but they say that in contempt jurisdiction, the court or the tribunal can also reverse whatever advantage has been taken of the contumacious action. So it was not beyond the jurisdiction of the contempt court or the tribunal to pass necessary orders for in consonance with 49(3) as well, which is a necessary fallout of 2.
But in this regard, my humble submission, in the
It will be a new order. You are saying
it's absolutely a new order.
We are unable to agree with you, Mr. Bhattacharya, that 49(3) is a different proceeding.
No,
No appeal is provided against it. No further action is provided against it. It has to follow 49(2), and 49(2) you may challenge.
But he could have made an application for possession, if there is an inaction, he can approach the tribunal. But this is absolutely a separate cause of action since he has not prayed for that. I can understand that if he has prayed for correction of the record of right and ancillary prayer was there.
Court even so to the judgment cited by him says so to also court can rectify, reverse whatever wrong has been done.
Especially that skipper judgment quoted in that first or second judgment.
Balwant judgment in Balwant.
I think 2024 SCC online
to see that
no, if your lordship kindly consider the judgment of 2023 17 SCC 545. Here, the fact is quite different because here there is a violation of court's order. Now, in the contempt proceeding, the court directed restoration of possession. So, initially he asking for protection of his right or the possession. The court granted that order. There is a violation. Now,
see that
there is a
2024 SCC online SC 3727 paragraphs 221 and 222. Please read that underlying portion and the next paragraph.
Rectifying the things done, violation of the order. Restrictive measure at any stage of the proceeding.
In contempt, court will definitely not supplant or supplement.
Yes.
Correct. But court will not keep its eyes shut towards the statutory provision, which is in force there. And that is a natural corollary, that 49(3).
Yes. Now, here, what I'm trying to impress, that
the question is the power of the contempt court.
Yes.
Whether they paid or not, when court takes it up, they bring it to the notice of the court that your order has been violated. The order was to correct the records of rights. If we hold that 49(3) is a natural corollary, it has to follow 49(2). And the language of 49(3) is apparently such.
Yes.
If that be so, then the contempt court can rectify what was not even paid for by them. And contempt court can direct whatever wrong was done to be corrected. So therefore, if the order is to correct the records of rights, in pursuance of the correction, this ought to have been automatic. Why should the tribunal in contempt relegate it to some other proceeding before the same authority which violated 49(3)? That is what is under confirmation.
My humble submission, the authority has not yet extended his scope to
No
49
further
3.
application is necessary. That is the difficulty, Mr. Bhattacharya. If you are
No, no,
right,
that is true, Manoj.
that is where we
49 to 49 3, there is no,
no distinction.
there is no distinction, Manoj.
Yes. That's why
That
we
is very clear.
specifically told you that we don't agree with your proposition that it's if it was a separate proceeding, then you would have a very good case.
No, Manoj, my misunderstanding was
No
that is a 49
No,
2,
not
Manoj.
that,
I
not
was
that.
under the impression.
Suppose we are forgetting you here. If it would be a different proceeding, and see, the scheme is very clear, as you pointed out the right sections, but the wrong arguments were made. But here, that's the specific scheme of this section. No separate appeal is provided for against three. Even under section 14 of the Surface Act, the magistrate's action is amenable to a challenge before the tribunal. Even although that's only ministerial to give effect to a surface action, measures under the that's ministerial, but still there is a provision of compliance of affidavits and all. Therefore, a challenge is provided. Here, no challenge is provided at all. So, therefore, we have to constitute this as a part of 49.2.
It reaches finality, my lord.
Yes, 49.2 and 3 are not separate provisions merely because of convenience. But 49.2 and 3 has to be read as a single provision for all practical purposes. That is what we are.
I can understand, my lord, that if there is a prior to that effect in the original application, or, my lord, in the record of right and ancillary proceeding,
no, there is a grey area, Mr. Bhattacharya, between actual contempt having been committed deliberately and a contempt having been committed or not committed, order has been complied with, but still something remains to be done. So there the court in contempt jurisdiction as per these judgments can come in and say, yes, you have complied to the letter with the letter of the order, but there are other things which happened as a corollary. You ought to have done those also. That is complete compliance of the order. So if I pass a direction under 49.2, then inbuilt in that is 49.3. That is what they are arguing.
Yes, my lord.
It's inbuilt. That is where, yes, you are right. Technically, you are right. No prayer. So we are not hauling up the BLLRO for this misunderstanding because we are interpreting here.
But in any event, my lord, if he approaches the BLN and BLR is bound by this because since he has already passed the.
He need not. That's what we're saying. 49.3, the language is very, very clear.
No, my lord, what I'm saying, since 49.2 has already been passed and that is affirmed.
But when a revenue officer makes an order under subsection 2 annulling such and such, the revenue officer shall enforce delivery of possession of such land to the collector by using such force as may be required. When he does it, he shall. There is nothing in between. No further application, no further hearing, no further proceeding, no further challenge even to that.
But Malad, here, Malad, the land, can you consider, Malad, the revenue officer shall enforce the delivery of possession of such land to the collector by using such force.
Not to them.
Not to them, Malad. That is also, Malad, troubling me, Malad, that it's to the collector. Now, Malad, the act remains silent that whether the collector will then, Malad, hand over the possession to them.
Now, 49.2, if you see, 49.2, revenue officer does what is satisfied that settlement was mistake on all, or that a transfer of land has been made in contravention of the provisions of 1A. He may, by order in writing, annul the settlement or both the settlement and the transfer. Transfer does not come in. No further transfer. So he may annul, that is the scope of 49.2. He may annul the settlement. So that comes within 49.2 itself.
Yes.
Here settlement was already annulled previously by the SDO. So what remained was to do 49.3 to the collector maybe.
To the collector.
We will hear Mr. Dhar on that collector part.
Then, again, Malad, he have to apply before the collector, Malad, for possession.
Exactly. That is what.
That is, Malad, that is a statute says, Malad. And the what shall is there.
Collector is given because this is a vested land. So it goes to the collector's khotian. That is why it's written collector.
The possession is to be given to the collector.
Collector, because in a district, collector is the custodian of that land.
Yes, but you are not the collector. Then the court could have directed possession to be handed over to the collector. Then.
Well, the consequences ultimately to the petitioners. Well, I thought during that time I would not multiply with the judgments, but there is a specific judgment on this by Honorable Justice S.B. Sinha that it has to go back to the petitioner. Whatever wrong has happened, if vesting is set aside, it's an corollary. Restore back and give it to the petitioners. If my lord, since I না দেখে না প্যারা 7 দেখে নাও সেম জিনিস একই জিনিস
সমস্যাটা তো তুমি ওয়েতে প্রেয়ারটা করলেই কোনো সমস্যা
ওয়ে আছে ওয়েতে প্রেয়ার আছে কন্টেম্পটে প্যারা 7 মানে
প্রবলেমটা কি বেরো দাও তো মামলা করতে Yes, para 7 sir. So 49 is not restricted to correction of the records of right actually.
That is only read with 49.3 or deals with the delivery of possession. There is no I'm restricting my argument only on the scope of the contempt jurisdiction.
Yes, yes. Well, let us decide. There is a checkered history to the matter. First off, initially, one Dijendranath Bhomik, the predecessor in interest of the present petitioner, purchased several plots of land totaling about 8.18 acres in Mouza Horipur, PS Namkhana, district South 24 Parganas through 3 registered deeds of conveyance from the original owner, one Gopal Chandra Hait, HAIT. Full stop. Thereafter, the predecessor in interest of the petitioner got his name mutated, got the lands mutated in his name, and revenue receipts were granted in his favor by the Block Revenue Office. Full stop. Next para. Subsequently, in the year 1969, a big riot case bearing number 548 triple I of 1969 was initiated by the revenue officer against Gopal Chandra Hait, the vendor, without notice to the petitioner's predecessor, who was a post-vesting. No, who was a push-up, thereby vesting the entire lands without giving sealing benefits. Push-up. Next para. Subsequently, the said Dijendranath Bhomik died intestate, leaving behind his widow and 2 sons, including the present, being the present petitioners. Next para, the petitioners made a representation to the BL and LRO Namkhana for mutation in their name in the year 2001. The BL and LRO having not acted upon the same, the petitioners moved the West Bengal Land Reforms and Tenancy Tribunal, which directed the BL and LRO, Namkhana, with the order dated August 16, 2001, to consider the representation and pass a reasoned order within 3 months, and, more importantly, to maintain status quo as regards possession of the lands. Next para. However, the BL and LRO, Namkhana, contravened the said order and issued Rayoti Patta to third parties on April 18, 2002, upon which the petitioners lodged a general diary entry bearing number 712/02 at the Namkhana police station. Next para. On August 12, 2002, the learned tribunal, in MA 242/2002 LRTT, directed the BL and LRO not to give effect to settlement of patta until further orders, within bracket, thereby effectively stalling the handing over of possession to the settlers in terms of the pattas. Bracket closed. Full stop. Next para. Subsequently, the learned tribunal set aside all orders passed in proceeding number 548 stroke III of 1969 and directed the BL and LRO to examine the case and pass final order. Full stop. Again, comma, the tribunal directed the BL and LRO to comply with the previous order dated March 26, 2003, comma, as narrated above, comma, by an order dated September 10, 2003, within 15 days. Full stop. Next para. Subsequently, on November 4, 2003, comma, the BL and LRO initiated case number 25/2003 and held that due to non-submission of B form, comma, the entire land had vested in the state, and the petitioners are post-vesting purchasers, comma, thereby not entitled to the benefits. So next para. The matter went up to the learned tribunal, which observed, comma, video order dated January 9, 2004, that the retention point is factual and cannot be decided by the tribunal, comma, granting liberty to the petitioners to make a reference to the SDL and LRO, comma, Kakdweep under section 57 capital B within bracket 3 of the West Bengal Estate Acquisition Act 1953. Full stop. Next para. Pursuant thereto, comma, a proceeding was initiated on October 11, 2004 under section 57B within bracket 3 of the 1953 Act. Full stop. By an order dated October 18, 2004, comma, the SDL and LRO Kakdeep disposed of reference case number 10 of 2004, comma, allowing the intermediaries to retain 25 acres, comma, including 8.18 acres purchased by the predecessor in interest of the petitioners. Full stop. Next para. Pursuant thereto, comma, the petitioners, comma, through their learned advocate, comma, applied for correction of records of rights in their names based on the order dated October 18, 2004. Full stop. Such application dated March 2, 2005 not being adjudicated, comma, the petitioners were constrained to file OA number 2750/2005 within bracket LRTT, which was disposed of by the tribunal on September 21, 2005, directing the BL and LRO to treat the main application as representation and dispose it of within 6 months. So next para. Subsequently, on July 4, 2006, comma, the ADN and DL and LRO, comma, South 24 Parganas asked the BL and LRO Namkhana to initiate proceeding under section 49 within bracket 2 of the West Bengal Land Reforms Act 1955 for annulment of the patta, comma, which is primarily the genesis of the present litigation. Full stop. Next para. Several steps later, comma, on November 11, 2010, comma, the BL and LRO submitted a report before the tribunal to the effect that miscellaneous case number 2 of 2010 had been drawn up, upon which the tribunal directed the SDO, comma, Kakdeep to adjudicate the proceeding under section 49 within bracket 2 within 3 months. Full stop. On February 28, 2012, comma, the SDO, comma, Kakdeep initiated case number 2 of 2012, 2/12 of 2012 for annulment of the pattas. Full stop. Next para. Importantly, comma, on April 26, 2013, comma, the SDO, comma, Kakdeep annulled all pattas granted vide RS case number 9/NAM/96-97 and RS case number 2/NAM/2001-02. Full stop. Next para. Pursuant thereto, comma, the petitioners again applied for correction/mutation of the LR records in their favor. On December 3, 2013, full stop, the BLRO sitting tight over the matter again, comma, OA 762 of 2014 bracket LRTT was preferred before the tribunal by the writ petitioners, in connection with which the tribunal directed the BL and LRO to take appropriate action for correction of the LR records of rights within 3 months. Video order dated June 16, 2014. Full stop. Next para. Ultimately, comma, the petitioners had to file OA number 645 of 2017 bracket LRTT, upon in which the tribunal directed the BL and LRO again to conclude the proceeding initiated in compliance with the order dated June 16, 2014, this time vide order dated September 11, 2017. Full stop. Next para. The petitioners, however, had to run from pillar to post, being constrained to file OA number 1319/2022 bracket LRTT, seeking mutation and implementation of the earlier orders. Full stop. In the meantime, the applicant number 1, Narayan Chandra Bhumik, died and was substituted by his legal heirs. Full stop. Next para. On June 6, 2023, the learned tribunal disposed of OA 1319 of 2022 as infructuous, against which WPLRT 104 of 2023 was preferred, which was allowed, setting aside the order of the tribunal disposing of OA 1319 of 2022 as infructuous and remanding the OA for hearing on merits within 6 months, by an order of a division bench of this court dated October 3, 2023. So next para. On June 28, 2024, the learned tribunal directed the BL and LRO Namkhana to correct the LR records of rights and record the petitioners' names within 2 months, and that the DL and LRO was to ensure compliance of such order. Full stop. Alleging violation of the said order, the petitioners filed contempt application bearing MA number 1682 of 2024 bracket LRTT. Full stop. Simultaneously, the state respondents filed an application bearing MA 311/2025 bracket LRTT against for review of the order dated October 28, 2020. Full stop. The learned tribunal allowed the contempt petition and directed the BL and LRO to mutate the names of the petitioners by October 27, 2025, whereas rejecting the review application of the state, all video order dated September 15, 2025. For sub next para, the state preferred WPLRT 195 of 2025 against the state order, which was disposed of by this court, affirming the order dated June 28, 2024, but expunging certain caustic remarks made in the order dated September 15, 2025, extending the time for compliance till December 10, 2025. Full stop. Next para. After several further orders, the state filed MA number 1820 of 2025 for recalling reviewing an order dated December 5, 2025, whereby the tribunal had directed the BL and LRO to prepare records of rights in favor of the petitioners without delay. Full stop. Next para. On December 17, 2025, the learned tribunal disposed of the contempt application by modifying the order dated February 5, 2025, December 5, 2025, observing that the tribunal's orders merged with the judgment of the High Court of this court in WPLRT number 195/2025, and as such, contempt should lie before the High Court. Before this court. Next para. A special leave petition was preferred against the same, which was dismissed on January 23, 2026. Full stop. Next para. Thereafter, the petitioners filed WP LRT 33 of 2026. What is the present? No. 2026. And a coordinate bench set aside the order dated December 17, 2025, directing the tribunal to dispose of MA 1820/2025 and MA 1682/2024 within 2 months. Full stop. Next para. Thereafter, by the present impugned order dated June 30, 2026, the learned tribunal dropped the contempt proceeding by accepting the compliance report of the BL and LRO Namkhana and refusing to direct delivery of possession to the petitioners, holding that recovery of possession is alien to the to the 1955 Act, and only the civil court can grant such relief. Full stop. Next para. The learned senior counsel appearing for the writ petitioners, assailing the said order dated June 30, 2026, submits that the learned tribunal failed to take into consideration that the BL and LRO, in his report, had only indicated that the LR records of rights had been corrected, thereby mutating the names of the petitioners, semicolon, however, without compliance of subsection 3 of section 49, which mandates the revenue officer, upon making an order under subsection 2 of section 49 annulling settlement, to enforce delivery of possession of the land to the collector by using such force as may be required after evicting the person in actual occupation of the land. Next para, by placing reliance on such and such, namta diye debe, reported at 1998 1 Cal LJ 171, learned senior counsel argues that within the contemplation of section 49 within bracket 3 of the 1955 Act, the restoration of possession to the collector tantamounts to restoring back possession to the petitioners in order to uphold the rule of law and correct the records of rights, inasmuch as the state and its officers cannot take advantage of their own wrong. It was held by a learned single judge of this court in the said judgment that if the state and its officers have delivered possession to the respondent under some misconception that the lands have vested, they should evict the respondent also so as to uphold the judgment and decree passed by a competent civil court, as also for the purpose of upholding the rule of law. Next para. Learned senior counsel next contends, by placing reliance on a coordinate bench judgment in Pashupati Das and others versus State of West Bengal and others, reported at 1999 1 CLJ 123, that if the lands cannot be contended to be vested lands, the transaction of settlement in favor of the appellants was void, appellants therein was void ab initio, and the question of any reasonable opportunity in compliance with section 49 within bracket 2 does not arise. Section 49 within bracket 2, in the view of the division bench, would be attracted in cases where there is scope for an inquiry where a cancellation is made, but not with regard to transactions of lands which were not at all at the disposal of the state government for settlement through patta. For similar proposition, learned senior counsel also cites the judgment of a learned single judge of this court in the matter of Sri Baneshwar Jana versus State of West Bengal, reported at 1992 1 CLJ 489. Next para, by relying on the said judgments, learned senior counsel seeks to impress upon the court that in the event patta has been granted to third parties under the erroneous impression that the land had vested in the state, the same can be nullified under section 49 within bracket 2 of the 1955 Act. Next para, dwelling, DWELLING, dwelling on the scope of contempt jurisdiction, learned senior counsel cites such and such, reported at 2023-17 SCC 545, where the Honorable Supreme Court, inter alia, observed that although the transfer of the suit property pendentility may not be termed as void ab initio, yet when the court is looking into such transfers in contempt proceedings, the court can definitely declare such transactions to be void in order to maintain the majesty of law. Apart from punishing the contemner, for his contumacious conduct, the majesty of law may demand that appropriate directions be issued by the court so that any advantage secured as a result of such contumacious conduct is completely nullified. This may include issue of directions either for reversal of the transactions by declaring such transactions to be void, or passing appropriate directions to the authorities concerned to ensure that the contumacious conduct on the part of the contemner does not continue to inure to the advantage of the contemner or anyone claiming under them. The beneficiaries of any contumacious transaction, it was held, have no right or locus to be heard in the contempt proceedings on the ground that they are bona fide purchasers. Next para, For similar contention, comma, learned counsel, senior counsel cites such and such Manoj Roy versus Primanshu Mundal and others, bracket SLP number ta diye diyo. Where the Honorable Supreme Court held that if there is any other document executed or acts of omission stroke commission by the contemners which is related or relatable to the act order under contempt, comma, the same shall also be withdrawn stroke reversed to restore the position as was existing prior to the date of the order. Push up. In support of the self-same contention, comma, learned counsel also, senior counsel also cites 2024 SCC Online SC 3727. Push up. This is part delivered. We'll continue delivery of this judgment after 2 p.m. We have a different time.
I'm mentioning to seek a leave to file without certified copy, my lord.
Mention in the morning. We should have mentioned in the morning.
Not. My lord, the next is on Monday, my lord, in between 2 days.
No,
my lord.
not at least.
একটা দশক ভেঙে
এটা আবার কন্টিনিউ করব। Only for judgment, yes. We are reading the operative portion. In view of the above, we answer the reference in the affirmative, holding as follows. A preemption application under Section 8 of the West Bengal Land Reforms Act 1955, whether on the ground of co-sharership, notified or unnotified, or otherwise, has to be rejected at the outset as not maintainable if the application is not accompanied by the statutory deposit of the consideration amount shown in the sale deed sought to be preempted, along with 10% thereon, irrespective of whether there is or is not any allegation that the price shown in the deed was inflated and the actual consideration money paid according to the preemption is a lesser amount deposited with the preemption application. CO number 785 of 2021 be now placed before the regular bench having determination to take up the matters for adjudication on merits. Following Abdul Motin.
I'm good.
Can I say? থ্যাংক ইউ। হ্যাঁ হ্যাঁ একদম ঠিক করেছেন। Next para. Thus, senior counsel for the petitioner contends that the learned tribunal ought to have directed restoration of possession as a component of its contempt jurisdiction. So next para. Learned senior standing counsel, appearing for the state, submits at the outset that the appropriate course of action before the writ petitioner was to take out a separate proceeding under section 49 within bracket 3 of the 1955 Act to obtain possession. Full stop. However, during course of arguments, learned senior standing counsel does not press such line of argument further. So next para. Secondly, it is contended by the state that in contempt jurisdiction, the court or the tribunal cannot extend the scope of such jurisdiction by passing further orders, thereby adding to the parent order which is under contempt. Next para. In support of such contention, learned senior standing counsel cites a coordinate based judgment of this court in the matter of such and such, reported at 2007 within bracket 4 CHN 996. Wherein the division bench observed inter alia that the purpose of contempt jurisdiction is to uphold the majesty and dignity of the courts of law, since the respect and authority commanded by the courts of law are the greatest guarantee to an ordinary citizen, and the democratic fabric of society will suffer if respect for the judiciary is undermined. Full stop. However, it was further laid down that it is to be kept in mind that the court exercising the jurisdiction to punish for contempt does not function as an original or appellate court for determination of the disputes between the parties, and the contempt jurisdiction should be confined to the question whether there has been any deliberate disobedience of the order of the court, and if the conduct of the party who is alleged to have committed such disobedience is contumacious. First up, the court exercising contempt jurisdiction, it was held, is not entitled to enter into questions which have not been dealt with and decided in the judgment or order, violation of which is alleged by the applicant. First up, next para. In line with such proposition, learned senior standing counsel vociferously argues that in view of the compliance report filed by the concerned BL and LRO, from which it is evident that the records of rights were corrected in consonance with the order of the learned tribunal dated June 28, 2024, nothing further was left for the tribunal, in its contempt jurisdiction, to do but to hold that the contempt proceedings had been rendered infructuous. Full stop. It is thus submitted that the tribunal was well within its jurisdiction to observe that to obtain recovery of possession, the petitioner had to take recourse to the appropriate provision of law. So next para, upon considering the submission of learned counsel, we find substance in the submissions of the petitioner. So next para, it would be profitable in this regard to reproduce the relevant provisions, which are as follows: section 49, subsection 2, within 2, 3, 3A, আর 4 এগুলো করে দেবে 2, 3, 3 capital A 4 of West Bengal Land Reforms Act 1955. Italics করে next para. From the scheme of the aforesaid provisions, comma, it is evident that subsections 2 and 3 of section 49 are in the nature of conjoined twins, comma, inseparable from each other. Full stop. For the sake of convenience, comma, the legislature has classified the said two provisions into two different subsections. Full stop. However, comma, in effect, comma, the two provisions are inextricable from each other. Full stop. The procedure laid down in subsection 3 automatically follows from and is a corollary to an order being passed under subsection 2 of section 49. Full stop. Next para. As per subsection 3, comma, when a revenue officer makes an order under subsection 2 annulling settlement, comma, the revenue officer within double inverted shall, double inverted close, enforce delivery of possession of such land to the collector by using such force as may be required after evicting the person in actual occupation of such land. Full stop. Under subsection 3, capital A, comma, for the purpose of enforcing such delivery of possession and eviction, comma, a written requisition may be sent by the revenue officer to the officer in charge of the local police station or to any police officer superior in rank to such officer in charge. And on receipt of such written requisition, comma, the police officer concerned shall render all necessary and lawful assistance for enforcing delivery of possession of such land. Next para. Thus, comma, upon an order being passed under section 49 within bracket 2, comma, there is no further option left before the revenue officer but to take recourse to subsections 3 and 3 capital A and ensure that delivery of possession is given, comma, upon evicting any occupants of the land. Full stop. Next para. Conspicuously, comma, subsection 4 of section 49 provides for an appeal against an order passed under subsection 2, whereas no such further challenge is provided for in the statute against action taken under subsections 3 and 3 capital A of section 49, comma, thus making it abundantly clear that subsections 3 and 3 capital A are but parts of subsection 2 and are not isolated therefrom. Full stop. The statute does not envisage any further or separate proceedings to be undertaken or application to be filed for setting the ball contemplated under subsections 3 and 3 capital A in motion. Full stop. Next para. Hence, comma, it is implicit in a direction to comply with section 49 within bracket 2 of the 1955 Act that such action shall also be coupled with possession being handed over upon evicting occupants of the concerned land within the paradigm of subsections 3 and 3 capital A of section 49. Full stop. Next para. Seen thus, comma, the direction on the BAL and LRO in the order under contempt dated June 28, 2025 to 2024 to comply with section 49 within bracket 2 incorporated within its frame the necessary consequential action under subsections 3 and 3 capital A as well. Full stop. Next para. Seen from a different perspective, comma, there is a gray area between deliberate and contumacious violation of an order of a court or tribunal and the powers of the court or tribunal under contempt jurisdiction. Full stop. Whereas the BL and LRO might have complied with the direction of the tribunal to the letter by effecting the necessary corrections in the name of the petitioner in the records of rights, comma, much was left to be done, comma, inasmuch as the BL and LRO also had to consequentially ensure that possession was handed over to the petitioner. Full stop. Next para, having not done so, comma, although we can grant benefit of doubt to the BL and LRO insofar as deliberate and willful violation of the direction is concerned, comma, simultaneously, comma, the tribunal could not have shut its eyes to the non-compliance of subsections 3 and 3 capital A, comma, which we have held to be virtually a part of subsection 2, comma, in not directing eviction of the occupants of the land and handing over of possession to the petitioner. Full stop. Next para. Learned Senior Standing Counsel has also insinuated that subsection 3 envisages possession to be handed over to the collector and not to the petitioner. Full stop. However, comma, in the light of the ratio laid down in Urmila Hallar and others, Supra, comma, which succinctly lays down the law on the issue, comma, the state cannot take advantage of its own wrong in having granted pattas in favor of third parties in respect of land which was not vested in the state in the first place. Full stop. Thus, comma, under contempt jurisdiction, comma, the tribunal, learned tribunal had ample power to set such right wrong by ensuring that possession was handed over to the writ petitioner, comma, who was lawfully entitled to such possession. Full stop. Next para. In the present case, comma, the pattas having already been annulled, comma, there was no further course of action open to the BL and LRO, but to take recourse to subsections 3 and 3 capital A of section 49 and ensure that the that meaningful effect was given to the correction of the records of rights and the annulment of the settlement in favor of third parties by handing over possession, comma, if necessary, by use of reasonable force, comma, and evicting the persons in actual occupation of the land, comma, in favor of the writ petitioner. Full stop. In the light of the
I'm sorry to butt, my lord. This paragraph, my lord, has mentioned the concerned BLLRO instead of, my lord, mentioning BLLRO under the act and the rule.
the
Revenue officer,
LRO na kore, the appropriate authority designated under the 1955 Act. Next para. In the light of the above observations, comma, this court is of the opinion that the learned tribunal refused to exercise jurisdiction vested in law by relegating the petitioner to the civil court, which, comma, in any event, comma, does not have jurisdiction in view of section 49 within bracket 3 of the 1955 Act in that regard, comma, and refusing to direct the BL and LRO to correct the wrong done to the petitioner as a necessary corollary of the order of annulment of the pattas and correction of the records of rights in the name of the petitioner. Full stop. Accordingly, WPLRT 163 of 2026 is allowed on contest, comma, thereby setting aside the impugned judgment of the tribunal, judgment dated June 30, 2026, passed by the second bench, comma, West Bengal Land Reforms and Tenancy Tribunal in MA 1682 of 2024 and MA 1820 of 2025, bracket OA 1319 stroke 2022, bracket close, bracket A, LRTT, and directing the which authority should which respondent should you direct?
my lord, the respondent number 4, that is the SDO.
Directing the respondent number 4, that is the subdivisional officer, comma, Kadbir, to enforce delivery of possession of the subject plots
to the petitioner by using such force as may be required after evicting the persons in actual occupation of the lands, comma, within the purview of section 49, comma, subsections bracketed 3 and 3 capital A of the West Bengal Land Reforms Act 1955. Full stop. Such exercise shall be concluded by the respondent number 4 within 4 weeks from the communication of this order to the said respondent. The parties and all concerned shall act on the server copy of this order for the purpose of compliance, comma, without insisting unnecessarily upon prior production of a certified copy. Full stop. No orders to cost. Urgent photostat certified copy, if applied for, be supplied to the parties. Affidavit is satisfied. Declare. Correct. Correct. ওই জায়গাটুকু এখানে। Thank you. এইটা একটু নিয়ম। Sorry, Mr. Bhattacharya. Yes. Yes.
Expedite disposal of the below contempt proceeding pending below the time.
Since when is it pending?
Well, last one. Two orders, not 24.
MA is what?
My MA for contempt. Regarding the certified copy, when the order has been passed,
pending only
page 27.
Filed it only this year.
27. You are saying page 27.
2025.
Page 27. The parents order, page 27. The 14th degree proceeding to supply the certified copy of the order. I do not obtain the certified copy, but I tribunal said the supply the certificate within certain time, but nothing has been done. For the reason I made contempt before the tribunal, that is pending. My page 27.
What is the next date fixed?
Can you see
17th of December.
My 7th.
7th December.
This is order for certificate copy not we have. I could not obtain the certificate copy.
The content within 6 months thereafter. That is pending. The grievance of the petition is that is the long pendency of the way and connected to content activities. This has been matter within 4 months, 4 weeks. 4 weeks. Within 6 months thereafter, wait. Wait within 3 months. 6 months thereafter.
Yes, you are passing.
Madam. Supply the certificate.
Affidavit of service filed to be kept in record.
Supply of certified copy means?
Regarding the 14th proceeding.
So that is contempt is pending. Contempt will directly
regarding to order passed by one tribunal to produce to give the certificate copy, supply certificate copy.
Yes.
My lord, order dated 7th.
We are not allowing the contempt from here. We are directly
The petitioner has come up before this court praying for expeditious disposal of OA 170 of 2025 with MA 236 of 2026. Next paragraph. The learned counsel appearing for the petitioner pointed out that lastly, the matter was taken up by the learned tribunal on 16th of July 2026 and the next date of hearing has been fixed on 17th December 2026. Paragraph. We have heard the learned counsel for the parties, including the learned senior standing counsel for the state. Next paragraph. We find from the materials on record that sufficient case has been made out for expeditious disposal of the petition for the original application pending before the tribunal along with the application for contempt. Next paragraph. In the circumstances, WPLRT 164 of 2026 is disposed of by requesting the learned tribunal to hear and dispose of the application for contempt being MA 236 of 2026 within a period of 3 months from the date of communication of the order, and to conclude the hearing and dispose of the original application being OA 170 of 2025 within brackets LRTT within a period of 6 months from the date of communication of this order. No order as to cost. Certified.
Get
প্রথমে হচ্ছে এফিডেভিট সার্ভিস ফাইলটি নিয়ে করে দিয়েছি, তোমাকে তুমি বাকিদের উপরে দেবে। যেখানে এমনি সিনিয়র কাউন্সিল বলছে সেটা ছোট হতে পারে, সেটা কোনো পার্টিকুলার ডেজিগনেশন আমরা রেখে দেবো। সিনিয়র স্ট্যান্ডিং কাউন্সিল হচ্ছে একটা ডেজিগনেশন, এপিপি সবকটা ব্যবসা। সিনিয়র স্ট্যান্ডিং কাউন্সিল এসএসসি তিনটেই তোমাদের দেখছি ছোট হাতের ওটাও করছো। সিনিয়র স্ট্যান্ডিং কাউন্সিল একটা ডেজিগনেশন।
Lord, I am for petitioner, my lord.
Yes.
Lord, what happened, Lord, after service of notice, my lord, I have gotten an envelope, Lord, returned, which received, Lord, deceased.
Deceased.
Lord, so, my lord, I am filed, my lord.
You are appealing for the deceased person?
No, my lord, I am appealing for the
Thank God.
respondent number 1.
Lord, I have, Lord, respect of 4.
Yes.
Lord.
So you take steps. You have to take steps.
Take steps, my lord. And file application, Lord. I requested my client not to take date of death. I do not
If
know.
you know, then you can. Oh, you are for the official. No, you can supply the particulars if you.
Yes, yes. I request my learned friend.
Huh?
If I know, my lord, I'll supply.
I request my learned friend to supply the middle same so that I can file.
Okay, learned counsel for the petitioner submit.
One prayer, my lord. I may permit to file a supplementary affidavit with some documents I have got, my lord, with relevant to this matter.
Okay, supplementary affidavit will permit you give copies to them.
My lord, primary.
Permit you to file it. You are ready with the supplementary?
No.
Yes, you are permitting it.
Fine.
How long will you take for that?
Within 1 month.
1 month. So let it go out of the list. We'll give you those liberties and mention after that. Learned counsel for the writ petitioner submits that from one of the envelopes which has returned upon attempted service, comma, it transpires that respondent number 4 has died.
4.
That respondent number 4 has met her demise in the meantime. Push up next para. Her heirs may be on record also. Alright. Anyway.
Maybe, Lord, I am the government respondents, so I do not know who are there.
Very. Full stop. Accordingly, learned counsel for the petitioner seeks some time to take out appropriate application for substitution stroke expunction of the name of the deceased respondent. Full stop. Learned counsel for the respondent number 1 who is appearing today, comma, is requested to furnish the particulars including date of death and names of heirs and names and particulars of heirs and legal representatives of the deceased respondent, comma, if available to his client, comma, to the learned advocate for the petitioner within a fortnight, within a week from date. Full stop. Next para. On the prayer of learned counsel for the writ petitioners, comma, further leave is granted to the writ petitioners to file a supplemented affidavit to the writ petition, comma, advance copies of which shall be served on the respondents before on the respondents. Full stop. Next para. Let the matter go out of the list for the present with liberty to the writ petitioners to mention the same as and when such substitution application is filed and supplementary affidavit is ready. Thank you.
Your Lordship, I'm led by Mr. Shiladito Borma. Unfortunately, his mother expired today morning, so he had to rush to the hospital.
When should you take it up? Tell us.
Your Lordship will be very grateful if you adjourn it for 2 weeks at least.
In view of a bereavement in the family of learned counsel appearing for the petitioner, comma, on the prayer of the petitioner, let the matter stand adjourned till September 18, 2026.
Grateful.
September, not 18, September 21, 2026. 21st September.
Grateful.
Thanks.
We are for the petitioners.
Yes. So Bhattacharya, you are there in this.
I'm what to say, but I have nothing to say.
But kindly,
It's a dispute between two private parties.
Private party has been served.
but sent copies, but some of
copies
the
won't-
some returned answer, my lord. Some of the envelope.
We'll take it up next week, then wait for the service. Within a week, it will be done.
But we use the address of the respondents, my lord, taking from the tribunal's
Answer
application.
means what is the endorsement?
That they are not insufficient address.
Did they appear in the
We-
tribunal?
We followed their given address.
Their original application.
Their original.
Then we'll take it. We'll deem good service. You file the file the affidavit of service.
Affidavit service is not ready since the
Since the affidavit of service is not ready,
take it up in next.
come on, let them attest and adjourn for the day.
আজকের জন্য adjourn. Next week.
May it please your lordship, I'm for the petition in item number 12, my lord. It's not yet served, my lord. That is the whole difficulty, my lord.
Not served.
Not served, my lord. Not
Why?
see-
You send before filing. I mean, immediately after filing.
Yes, my lord.
When did you send?
Lord, not yet sent, my lord. That is the whole difficulty. My
Then
advocate
it
on
goes
record,
out
my
of
lord.
the list. Sorry.
My lord,
The counsel for the petitioner submits that
my lord, my advocate on record, my lord, requested me, my lord, because he has fallen sick. That is why, my lord, he could not serve, my lord. Just before 3 days, my lord, he received the number of this matter, my lord. I'm
the
praying
counsel
for.
for the petitioner submits that no copy of the writ petition has yet been sent on the respondents. First up, accordingly, let the matter go out of the list with liberty to the petitioner to mention for inclusion in the list as and when copies of the writ petition are served on the respondents.
My lord.
My lord.
Well, in this matter, I'm for the petition.
Madam, the last occasion your lordship directed me to produce the record, my lord. It has not yet come, my lord. Kindly accommodate me for a week, my lord.
How much?
A week time, my lord.
Week.
First it was the SIR, but then it was a different set of counsel.
Well, actually, they relied upon an order passed in the appeal.
If they can't find it, then it will.
Consequence will follow.
So Bhattacharya is submitted. Fair enough. Let us give them some more time. Learned senior standing counsel submits that the state was directed to produce the records on an earlier occasion. However, despite best efforts, the records could not be obtained as yet. Accordingly, on the prayer of the state, the matter stands adjourned till September 7, 2026. Monday week. Today is Friday, Monday week.
Yes. Actually, we filed an application on the RTI Act, that is in the file. They said no record, nothing of the sort. However, they are taking time.
No, Mr. Bhattacharya is there. We are sure that he will make his best effort, and he's done.
Yes.
Both of them are fair enough. They'll try their best. If they can't find, then it is difficult.
তা কবে হলো 6th না
7th. 6th is a Sunday. 7th September. to 16.
ওই নামগুলো আছে
None appears for the petitioners at the time of call. Full stop. As a last chance to the petitioners to move the matter, the same is adjourned for the day. Yes. Order get it up. Yes, Mr. Bhattacharya. Take your time. Take your breath. Time. Apparently, not a very good matter.
Land reform tribunal first.
No, from the face of Mr. Bhattacharya, it's a very Mr. Suprabhat Bhattacharya, not you. You are going out. That means your matter also is similar. Yes.
Against the order of the my lord.
Bhattacharya, same.
West Bengal Land Review Tribunal, my lord, 14 November 25. In this case, my lord, Raned Tribunal did not consider three things. First, my lord, judgment and degree of the Raned judge, civil judge Indian division, which was degree, my lord, in presence of the state government.
One second, Mr. Bhattacharya, the proceeding before the tribunal arose from what?
My lord, against the order of the my lord, Land Review and Tenancy Tribunal. Tribunal?
No. You went before that. It was your application before the tribunal?
Yes.
What did you challenge in that before the tribunal?
Tribunal challenged the in spite of the judgment degree of the civil court,
Yes.
as well as the order of the land tribunal. When the land tribunal was pleased to set aside the judgment, set aside the vesting order, and directed it to consider as a 14U. In spite of that, the land tribunal did not consider the same.
PLL order is not.
No, tribunal order did not consider. Again,
Not consider.
Consider regarding my vesting order.
Who did not consider?
BLRO.
That is what you are saying. You are saying tribunal did not consider.
No. Now my tribunal order is this. That as I am the
No. Then it was not complied with. Then you filed a contempt or sought an implementation.
No contempt application. But your lordship kindly wait for a moment. My lord, the order of the land.
Give us the chronology first. Tribunal passed a direction.
Yes, ma'am.
Setting aside vesting.
Yes, ma'am.
And directing what?
Directing
records to be corrected.
Records should be and new Khotian will be opened.
Well, that was not complied. You approached the BLLR with that order.
Yes, ma'am.
Not complied.
Not.
What did the BLLR do? Refuse.
Not consider. Not
inaction.
No hearing was there.
Inaction.
Inaction.
You moved the tribunal complaining of that inaction.
Yes, ma'am.
Now what has the tribunal done?
Tribunal passed an order that a post-vesting purchaser, I have no right to mutate or any other thing.
So thereby reopening the civil court's degree.
Yes, my lord.
We are supplying the arguments to you. What is your argument?
My argument, my lord, will be twofold. One, judgment degree who has passed in the presence of the state of West Bengal. And second, my lord, my argument, my lord.
Judgment degree passed in the presence of state means? How does that matter?
My lord, actually, state of West Bengal did not paper any appeal. Did not paper any appeal against the judgment degree. Thereafter, my lord, when tribunal passed and my lord, on your lordship is the 19 March 2001. Only my lord, your lordship is where the learned tribunal, my lord, passed an order.
Where do you find it? Which page?
Page, my lord. There are 2-3 annexures are there, my lord. First, my annexure, my lord, page 22. P1. Page 21, man, your lordship kind of 22, page 23.
Yes.
Second paragraph, my lord. Yes. In the aforesaid circumstances, we propose your lordship got it, my lord.
Got it. Your lordship got it. Both of our lordships have got it.
To pass a direction of the learned BLRO, company take district South Chorizo to deduct an equal of quantum land from the petitioner's vendor's predecessor interest, of which is the successor is still in possession, by reviewing the BR case, which was initiated in the name of Bhudnath and effect collection of the record of right, that is 44(2)(a) of the West Bengal Estate Acquisition Act, without waiting for any approval from any authority. This is the order of the tribunal. And the collector's quotidian number 1, that is vested quotidian, and vested land register should be corrected. Simultaneously, my lord, all concerned should be informed and all consequent collection corrected record of rights. Here, my lord, the learned judge, only, my lord, Rajawala Barik, my lord, case. Rajawala Barik case where statute when permit the petitioner to show Rajawala Giri case is perfect, and my lord, on the basis of the Rajawala Giri, they are, my lord, learned tribunal, my lord, please to dismiss my
Learned tribunal relied on this.
Relied only, but my lord, my submission will be indifferent.
What was held here, Mr. Bhattacharya?
Only one.
Post vesting transfer.
Yeah. Here, my lord, Atul Chandra Mahato, it is also full bench judgment. It is not considered also, my lord. Here, my lord, Atul Chandra Mahato, the subsequent purchasers' right should be considered, and my lord, an opportunity of hearing was given.
But post vesting transfer, there's a bar in transfer once it is vested.
But my lord, may I submit only one thing?
How can it be
My lord,
transferred?
suit was degree, they did not paper any. Tribunal passed an order, they did not paper any appeal. After waiting 16th year or 16 or 17 years, they say that it is a post-vesting purchaser, you have no right. But my lord, in another case, my lord, your lordship considered the Atul Chandra Mahathur case, my lord. Here, subsequent purchaser right.
So both are three judgments. Yes. What was held here?
That depend the person interested to the show, my lord. However, the expression is used with the intent to
Which
give
paragraph are you reading, Mr. Bhattacharya? Which paragraph?
20, 22, 23, 27. My lord. Persons interested the date of vesting line and the said expression does not include subsequent purchase after the date of vesting. That would be contrary to the principle of natural justice. In your view, the intention of the act and the rules in the matter of preparation of revision of record order is to give opportunity. My submission will be only, my lord, Bogol and Neighbor officer, even subdivision land and land officer did not consider much difference. Even after judgment and degree, as well as the order of the land tribunal 19/3/2000.
Paragraph 21, the court held that it is held that we respectfully agree with the view in the case of Monoranjan such and such. If it is held that the expression persons interested means only those persons who had interest in the land or tenancy on the date of vesting, and the said expression does not include, that would be contrary to the principles of natural justice.
And ultimately, my lord, for the reason we are last 27 paragraph.
আপনি একটুখানি স্টেট অ্যাকুইজিশন একটা দিন ওই আগের ম্যাটারই তো আচ্ছা থ্যাংক ইউ আমার কাছে আছে let's come to 44(2)(a) once.
My submission, my lord, only to consider my and dispose of the representation made by the petitioner on the basis of the, my lord, order of the learned tribunal. Your lordship can see that this is a different case. Learned tribunal passed order, thereafter, my lord, this tribunal also, same tribunal, whether the, my lord, central tribunal can recall its own order.
Atul Chandra Mahato was cited before Rajwala. Absolutely. What did the tribunal hold? Let us see.
When a degree has been passed, my lord, degree is binding upon the all concerned. The authorities are bound to record the name Though it is vested, my lord.
In the decree, in the suit, the state was a party.
Yes. It was party and my lord, your lordship. That is the page 43, my lord. Even the vesting story, my lord, also defendant number 2, State of West Bengal contested the suit.
Suit was for declaration of title.
Yes. And my lord, WL written statement we got filed before the legal that the land was vested and created a fictitious tenancy of Benami.
The question of vesting did not come up in that suit. Did the state take a point that it had vested?
My lord, but
You have not gone to the judgment. Yes. Not vested. State government did not give any evidence, oral or documented, to show that Bhutnath was a big rat, etc. Hmm.
only ground, my lord, learned tribunal without considering the written argument also, my lord, you also got the page to page, my lord, written argument. That
Your
was
application was only for consideration of your representation. You said, relying on Atul, that you had a right of hearing at least.
yes, on the basis of the order of the first land tribunal cases.
Your representation was for correction of the records of rights in your name, mutation or what?
Correction.
Let us say, Mr. Bhattacharya. Yes, Mr. Bhattacharya. Now, in the subsequent judgment, we are coming to the civil court's decree later. Justice, this Rajbala Bari, here, as you rightly pointed out, para 10, it has been noted. But this matter, Rajbala's matter, the three-judge bench clearly distinguished that case from Atul on the ground that in this reference, the question of service of notice under section 44(2)(a) is not the one which we are deciding. We are dealing with the right of a post-vesting transferee to retain vested land in exchange of retained land of the intermediary. Now, therefore, line of distinction was drawn. Therefore, what was held ultimately, if we harmoniously constitute the two, he may have a right of notice under 44(2)(a) as held in Atul, because Atul clearly took into consideration this the person's interested this thing, and held that if it is held that expression personally means only those persons who had interest on the date of vesting, it would be contrary to the principles of natural justice. Therefore, post-vesting transfer is also entitled to a hearing. A notice means a hearing. So, on that count, why can't we say that this is distinguishable? Rajbala was distinguishable.
But the present fact of the present case is similar with the
Rajbala.
Rajbala. If your lordship kindly consider the first order of the tribunal.
Yes, exchange of retained land is also there.
Yes. Kindly come to page 22.
22, yeah, there is. We never left page 22 because that is the basis.
And here also, the question of this right of a post-vesting transferee retain the vesting land and in exchange of the retained land. That was the order passed. And this order passed, my lord, on perhaps in the year of 2003.
2001.
One. Now, my lord, this order was passed that has not been complied with. Challenging that inaction, my lord, he preferred the second application. Now, meanwhile, my lord, this judgment has come, which is specifically deals with this identical issue. Here, the only distinguishable factor is that original intermediary file a suit and obtain an order. But even if in my humble submission, even if he is my lord equipped with a decree of the civil court, but he has not challenged for recording of his name. Now, whether
the civil court's decree, because the civil suit was maintainable in the sense that title was declaration was sought, others are constrict. Although title was based on these questions which are barred under 57B, or what is the provision?
Yes, 57B,
57B. But you are the state, you appeared there.
No, this is the ex parte decree, my lord.
No, ex parte decree is equally binding.
Yes,
So
yes,
sorry,
I am-
did
I
not
am not
appear.
on that, my lord.
You are a party that is binding on it.
Yes, that is
After that, how
is
can
there. I cannot.
how can you question? How can the tribunal even question a civil court's decree? It
Well,
can be questioned under certain circumstances. Yes, we have held in certain cases.
But I have also preparing a written notes of argument regarding this 57B. So it's a quite little bit exhaustive. I need 1 or 2 more days time. In appropriate matter, I will show this 57B is to distinguish 57B. I'm preparing this.
57B distinguish means where civil court's decree
is not binding. As on the last 3-4 days ago, in Abdul Shakhtar matter, your lordship held that when there is no.
We have held both ways.
Yes.
But we have distinguished between one
So
and
far as the declaration of title is concerned, the civil court has the exclusive jurisdiction. But so far as any suit pertains to the correction of the record or something, that is barred. So, considering all these issues,
you prepared that, then you bring the judgments because we have to
I
deal
will
with the
bring all
judgment.
the judgment. Since very inception.
Yes, we have to deal with the here. This is a question which we cannot brush aside. Civil court's binding effect.
Yes, civil court judgment is there. Now, I think Mr. Bhattacharya's the best argument is that once the civil court judgment is there, so this is no more a vested land. Now, the applicant purchased after the judgment of the civil court.
That was obtained by his predecessor.
Well, to obtain, kindly appreciate me. The predecessor obtained a judgment of the civil court.
Yes, that is what we asked.
And when the civil court declared his title, so it's no more a vested land. Now, he's transferred the property in favor of Mr. Bhattacharya.
His title was declared against this
title was declared. Now, the question is whether he is at all a post-vesting trustee or not. Because once the
vesting goes, then there is no post-vesting.
No post-vesting transfer.
So, two grounds. One is that whether the interplay between these two judgments, civil court's decree effect.
Yes, because as reading from this petition, this present petitioner, if we hold that the civil court judgment is the binding upon the state and all the authorities, then he cannot be termed as a post-vesting transfer.
Exactly.
So
besides, these judgments do not come in.
Yes, once the vesting goes, so there is no question of any post-vesting transfer.
Very well. How soon can you prepare? Give a copy to Mr. Bhattacharya so that he can also deal with it.
Yes. Kindly, Lordship, kindly take the
tell us.
Fix on the next Friday, my lord. Meanwhile, but by Saturday, Sunday, I will prepare. But another written notes I have to prepare for this.
They will keep it Monday week because
Yes,
5 days we don't know. Sometimes we have broken benches. Primarily, two questions call for consideration in the present writ petition. Roman 1. Whether a post-vesting transferee, if the petitioners can be so termed, has a right of hearing on the question of mutation of a purportedly vested property, Roman 2, whether the decree declaring the title of a person in a suit where the state was the defendant is binding in the teeth of section 57 capital B of the West Bengal Estates Acquisition Act 1953. Upon hearing learned counsel for the writ petitioner, learned senior standing counsel, tinti capital senior standing, appearing for the state, seeks an accommodation in order to place before the court all the judgments governing the field on the above questions. Accordingly, let the matter stand adjourned till September 7, 2026 for hearing.
You also consider 19th March 2001 order also, my land tribunal of judge. There are also elaborately discussed, my lord.
No, we'll consider that also. আচ্ছা থার্ড কোশ্চেন একটা ফর্মুলেট করে দিও থার্ড কোশ্চেন একটা ফর্মুলেট করে দাও whether comma in view of no challenge having been preferred to the order dated March 19 2001 passed by the learned tribunal comma the learned tribunal subsequently acted without jurisdiction in refusing to act in terms of the same and reopening the same comma sitting in coordinate jurisdiction. That too.
15, 16 আমার আছে।
Pardon?
15 and 16, my lord.
15, 16 তাহলে একসঙ্গে একটা আচ্ছা তাহলে একটা হবে 14, 15 and 16.
My lord, item number 17 in this matter, Mr. Sanjay Mukherjee is appearing on behalf of the petitioner. My lord, inadvertently he has missed the brief today, my lord. My lord, he has asked me to seek for an
I
accommodation.
am for the middle opposition.
Only not
Number
to
6. I am for 6.
He has a defense of truth, like a defamation case. On the prayer of the petitioner, the matter is adjourned for the day. Please give your names, please.
Item number 18 to 23.
18, I am appearing for the writ petitioner. But this is a challenge. But the landlord,
Yes, I'm for the respondent number 11819.
for number one, oh, okay.
You are also on the panel now. Good.
But
Who is for the private? You are for the private response.
But advocate of mother-in-law, right, has not shown.
Follow me.
For not this week. Not this week.
Don't have any control over.
I can't.
Due to personal bereavement in the family of learned counsel for the private respondent, an adjournment is sought. So accordingly, let the matter stand adjourned till September 7, 2026. Next Friday is a holiday in India.
Yes.
We see a red mark there. Janmashtami. Monday week there.
Grateful.
None appears for the parties. The matter is adjourned for the day.
But we are appearing for the state.
Oh, sorry. This is item 24.
Oh, 24. No, my lord. Sorry, my lord, I am not there.
There. No, that is
It is the petition.
Yes, yes.
I am not here.
Yes, you are there.
Previously, when the matter was not assigned, subsequently has been.
No. State is the petitioner. You are appearing for the petitioner.
Yes, man. Subsequently, it has been assigned. It is a baje mamla.
They assigned means?
Well, assigned to some.
So Banerjee was also there.
Yes, Malad. We both were appeared. Subsequently, Malad, the learned GP has assigned the matter to some other learned advocate.
Who is the unfortunate person? You. You are also there. All three of you are there. No. We'll hear it.
Malad, Mr. Banerjee will argue, Malad. He has prepared.
There's nothing in the matter.
But he has prepared, Malad. He found so many law points in this matter.
We are now apprehensive.
Last occasion, my learned friend said the same thing, and your lordship asked us to give a short notes, list of dates, so that your lordship may dispose of it.
List of dates and list of dates. Yes, short notes is still better.
List of
No, Mr. Bhattacharya, I mean, we don't understand your submission. Who will appear then?
Malad.
Your entire set will not appear. Mr. Banerjee has prepared the matter.
With the lead. Well, initially we were assigned, my lord, and I argued the matter also on the last petition. But subsequently, the learned government peters has assigned this matter to somebody else. But I have been, my lord, we have been told that not to appear in this matter anymore.
Oh.
But verbally, my lord. But the assignment has already been made. So that is the difficulty, my lord. If your lordship may kindly give us a day's accommodation, so that at least we can.
We are at least. Huh? We are keeping it on 7th, then 7th September. A case summary stroke list of dates is filed by learned counsel for the respondent in compliance with our previous observation dated July 14, 2026. Full stop. Next para, however, learned senior standing counsel submits on instruction that the matter has now been assigned to a different set of counsel from the panel for the state. So accordingly, on the prayer of the state, the matter is adjourned till September 7, 2026. So it is expected that the state shall come prepared with the list of dates as per previous direction on the returnable date. Please apprise whoever is there. And Mr. Banerjee, you just help out whoever is appearing.
Well, I will.
Oh, thank you. After taking Putra matter is yes, call.
But 25, it will take time.
But not to,
but so much more than 300 pages. Two volume.
But এখন দেখি যে এরকম কোনো খুচরো কিছু আছে Mr. Giri, you are appearing that it cannot be done in 4 minutes.
26 million.
Lahiri is behind you. No, we are calling our orderlies. No, actually, in 4 minutes, 3 minutes are left. So, because
It will not be
break up. Very well. Then, chalo. What is the correction? Yes. Order sheet.
Lordship, in the first matter, the first contempt matter, the writ petition year is inadvertently recorded as 2024. It will be 2021, Your Lordship.
CPA 1991 of 2024.
2024, this is right, but the WPA number 12855 of 2021.
It's appearing as 21.
Lordship, in the order, it is recorded as 2024.
কোন order? Oh, আচ্ছা, পরের order. All right. All right. This is the only correction?
This is the only correction,
Very
Your Lordship.
In the judgment dated July 10, 2026, in the caption, WPA 12855 of 2021, was erroneously transcribed as WPA 12855 of 2024. Full stop. Accordingly, let the said judgment be deemed to stand corrected to the effect that double inverted WPA 12855 of 2024 shall stand deleted and be read as WPA 12855 of 2021. Full stop. Let this order be deemed to be incorporated in the judgment dated July 10, 2026. Thank you.
Grateful, Your Lordship.
Thank you. Yes. What happened?
One
Single bench?
single bench, contempt application.
Yes. You'll get an opportunity every day in the single bench. Yes. Mr. Dasgupta's matter is released. Your matter is released on personal because you are appearing. No, your matter is not released. Same matter. We'll hear you only. Yes. Who is appearing? Mr. Lahiri, you are appearing 11 to 14? 11 to 13?
Yes. I'm for the State Bank of India.
Right. Everybody is appearing for the state now. It is all the
State Bank.
State Bank.
of
Thank
India.
God.
Well, that's CBI matter, Miller.
Oh, yes.
Section
Yes,
6.
Yes.
I mean, led by Ms. Noel Banerjee. She's,
You are there. Start the matter.
my lord,
I'm led by Mr. Suresh Trivedi, my lord, is coming, my lord, for the CBI.
He will eternally come, but he is too busy.
No, my
You
lord.
will have to start. Yes, what is the matter?
my lord will kindly give me a crossover. She's coming. We have got instructions not to begin without the leader.
She has instructed you. Will Achha, very later come. Passover, Mr. Lahiri. Passover means one matter Passover. If the next matter flops, then again. চল কোন 50 Passover সাইডে থাক না এটা এক্ষুনি হয়ে যাবে ও yes হবে না yes Passover means it will take some time. Yes, Mr. Shana, let us hear you. 15 14 sorry.
My lord, I take your losses to the order first, passed by your lordships. That's at page.
একটু নামিয়ে দিন কারণ টাইম একবার গিয়ে কি ভদ্রলোককে বলে দিতে হবে যে 4:05 উঠবো চিফ একবার ডেডিকেট 4:00 সময় Mr. Shanal, today we will be continuing up to 5 minutes to 4 because 4 we have some official something.
3:30 is there.
Oh, 3:30 is also there. Very good. You start.
Now your losses, my lord, kindly your losses order dated 14th August 2023. In my your losses probably in the record your losses in the
14th August orderটা কোথায় গেল 14th August there was an order 2020
free
ও আচ্ছা ভালো গেল পেছে গেলে নিজে
416 on the deed petition man.
No, আমার application.
Are application আছে order was passed on the deed petition. I have annexed my lord at page 469 because
আচ্ছা you also annex. Very good. Let us see the annexes. 469. Yes, first.
Well, I just placed this order because learned senior counsel appearing for the petitioner contains that the demands made by Kolkata Electric Supply Corporation Limited for supply of electricity to level lines of the petitioner's industry were palpably arbitrary and ought to be set aside. By placing the concerned bills for the relevant periods, as well the notice dated August 2, 2023, threatening disconnection in default of payment of the alleged outstanding amounts. It is contended that the CSC Limited has disclosed almost nothing regarding the exact period for which there were incorrect recording of meter readings and the exact units consumed during the period. In view of there being no such
Mr. Shamlal, I had passed in single. This is single. Sorry. Yes, please continue. Forgot. Yes. Whether I can take up a. Yes. Incorrect reading, recording.
In view of there being no such allegations, up to the month of May 2023 and after July 2023 onwards, the sudden inflated bills for the months of May and June 2023 is without any explanation at all. It is contended that admittedly, the meter in question doesn't suffer from any defect whatsoever. There is also no tampering charge on the part of CSC Limited. As such, there is no rationale behind the exorbitant bills raised for the months of May and June 2023. In the event the CSC is of the opinion that the said bills were raised for respective periods, retrospective periods, the CSC is always the issue of the bar. There is always the issue of bar under section 56(2) of the Electricity Act 2003 being operative, since in the absence of specific disclosure as to the relevant period, there may very well be assumed that the period for which such alleged underbilled amounts are charged were beyond 2 years from the date of raising of the bills. That apart, there is no justification whatsoever in the impugned demand notices it is contended. The learned senior counsel appearing for the petitioners thus submits that the said bills for the month of May and June 2023, as well as the impugned notices, should be set aside. It is further contended that the proposed disconnection by CSC Limited shall adversely affect about 12,000 family members of the laborers who work for the petitioner's company and live in the labor lines where the electricity in question is supplied by block meters or several clusters. Learned counsel for CSC Limited submits that the writ petition is not maintainable, since the challenge as preferred in the present writ petition pertains to a billing dispute which has to be resolved under the governing regulations before the concerned grievance redressal officer. Secondly, it is submitted that even without making any charge of tampering and or faulty electric meter, the demand notices themselves disclose they were incorrect recording of the meter readings for several months prior to May 2023. It is submitted that there is no bar in the distribution license to raise subsequent bills on account of mistake committed in the meter readings. That apart, the writ petitioner, it is argued, has not disputed the units consumed during the relevant period. Hence, the present challenge is toothless. Upon hearing the learned counsel for the period, transpires that the bills for the month of May and June 2023 raised by CSC Limited against the petitioners for supplying electricity to the labor lines of the petitioners' workmen are palpably without any basis. On a plain reading of the bills for the previous and subsequent months, it is clear that the amount raised and the alleged units shown to be consumed as per the bills are explicitly exorbitant. The impugned bills are demonstratively exorbitant compared to the previous bills. The explanation of the CSC Limited afforded in the demand notices dated August 2, 2023, annexed at page 383 of the writ petition, throws precious little light on the said issue. In the very first instance, the CSC Limited admits that there were incorrect reading of the meter readings on the part of CSC Limited for months together prior to 2023. There is no disclosure whatsoever as to the exact months regarding which there was incorrect meter reading and what were the actual meter readings for the said months. That apart, no breakup whatsoever has been provided by the CSC Limited for charging such exorbitant amount for the months of May and June 2023. My lord, your losses, kindly keep your losses in mind. This is the breakup your losses recorded. Breakup probably your losses a month-wise breakup. CSC Limited itself admits the meter was not tampered and did not suffer any fault. Hence, the reason for the incorrect readings or the basis of charging such exorbitant amounts is not also disclosed. Contrary to the argument of CSC Limited, the demand notices themselves afford an opportunity to the petitioners to clarify the discrepancies, if any, in the bills.
The notices itself stipulate to avoid disconnection. The CSC Limited urges the petitioners to immediately make payment of the outstanding amount or contact the undersigned, that is the Assistant Manager Commercial, Howrah Regional Office, to avail installment facility. It is also disclosed in the said notices that is, it is imperative that the petitioners act promptly in the demonstration of their bona fide. Bona fide is misused term in the demand notices since the bills of sale itself are arbitrary. The notices contain threat of disconnection in the event the petitioners do not pay the exorbitant amount charged, since it affords only two options to avoid disconnection: either to make payment of the outstanding amount or to contact the author of the communication to avail installment facility, both of which compel the petitioners to pay up. Malad, there was third option, but your lawsuit has not, probably this was not submitted before your lawsuits. Hence, no prior opportunity of hearing or representation was given to the petitioners. More importantly, the demand notices are absolutely opaque and they do not disclose any basis for the overcharging. Hence, the said notices cannot survive judicial scrutiny. Insofar as the point of maintainability is concerned, hence the demand notices impugned herein and the bills for the month of May are palpably arbitrary and unreasonable. This court, within its power of judicial review under Article 226 of the Constitution of India, is very well empowered to interfere without unnecessarily relegating the petitioners to a fact-finding authority. The challenge preferred in the representative is not on broad principle of natural justice, is on and does not require a fact-finding inquiry at this stage. Accordingly, writ petition is allowed on contest, thereby setting aside the bills raised by CSC Limited for the months of May and June 2023, as well as the demand notices dated August 2, 2023 issued by CSC Limited against the petitioners, which are impugned in the present writ petition. The CSC Limited shall raise fresh bills indicating the exact breakup for charging the amounts in the said bills. Well, this is one part. For the months of May and June 2023. Well, if you can read it simultaneously or we can read it one or two. If any, by clearly mentioning the exact months when incorrect recording of the meter readings took place and the exact units consumed during such months and the charge thereof. We have prayed for now clarification or modification of this part of the orders. That I will be taking lots of note. As such, the bills for May and June are fresh, liberty given again, and nothing in the order precludes from issuing current bills for the continuing. That's one. In the events which issues fresh bills in compliance with the order of this court, the petitioners have a further grievance with regard to the breakup, quantum, and other factual issues on the same. It will be open to the petitioners to approach the grievance redressal cell. But I take your lordships to the, I think that would be better for me, the application itself, your lordships, what we have said in the paragraphs. Paragraph যেন ছিল বলতো ওই যেটা narrate করেছি আমি now your losses will find well, I think my lord, your losses kindly paragraph my lord 6 at page 12 of the application. My lord, what have been stated, I will just place it in the application. Upon the said order being passed, the applicant initiated the process of generation of false bills for the period which had gone unbilled, and the applicant stumbled upon an insurmountable difficulty. It was found that while providing the details of the exact months which went unbilled as possible, the same was not possible for the unit consumed by the petitioners, represented by the writ petitioner, during the said period, inasmuch as the period during which electricity had been consumed but not billed spanned over as many as 28 months. Then, in fact, the applicant's official meter reader, who had been assigned the task of tasking the readings of the meters installed at the subject premises, had been recording incorrect readings for a period of 28 months. And such fact came to the knowledge of the applicant only in the month of June 2023, when the meter reader, who had been taking the meter readings. Thus, far was replaced by another meter reader. As the newly appointed meter reader reported a substantially high meter reading in respect of the same premises for the month of June 2023, the applicant got alarmed and then analyzed the consumption pattern of the consumers as also the respective meters, whereupon it revealed that the units found to have been consumed as indicated by the new meter reader had indeed been consumed, but the same had not been billed for. To be precise, the meter reading reported for the month of June 2023 by the new meter reader was so high that the same could not have been registered in 1 or 2 months. It is under such circumstances the bills for month of May and June 2023 had been issued under the cover of a letter dated 20th August 2023, including therein the areas of the unbilled consumption, while the exact months in respect whereof the same had been billed had been indicated in the said bills. The units consumed had been collectively indicated in the said bills. Upon the order dated August 14, 20 being passed, while attempting to detect the exact consumption, this is in respect of the said months, it could be found that it was indeed an impossible task. Month-wise breakup, my lord. Total like
possible. How could you charge them on the basis of that?
Then, my lord, difference. The meter reading I found which was wrongly not recorded or taken, and what was I billed?
If you take the meter readings now, that will be for a current period. How can you know that what was previously?
Now I give an example.
You have a further recording in your office.
No, I think I give you losses. I have billed your losses today. The present meter reading 2000 units. Present meter reading.
Yes.
The current meter 2000.
For this month, 2000. Suppose.
That's in units consumed. Your losses bill will find previous meter reading, present meter reading. Then balance your losses.
Today you will find the meter reading. It's cumulative. It's like this. The meter in a car. I mean the total number of units consumed during the entire period is recorded.
Yes, yes. For the month. Now, give
only for the month or for entire.
I give an example. I give an example. Suppose
entire.
Since my lord,
kindly allow me
since
to
the meter
explain,
was
otherwise this will be difficult.
Since the meter was installed till today, whatever units have been
exactly proceed with that. But what with the bill, my lord, suppose we are raising your bill, your losses, consumption month 1, billing month 1. Now suppose consumption month January, billing month will be February. In January, what X has consumed in the bill in the month of February, we will show previous reading and present reading. The minus is the consumed. Now, what has been done here, your lordships? Actual reading recorded by the meter was not recorded. What was recorded? Less than the recorded in the meter. Suppose your lordships, current meter reading was recorded 2000. Recorded. Previous your lordships 18,000. 2000 if not correct. If it is 3,000, then it should have been 200 consumed.
How did you calculate the difference previously?
That's similar. We are getting from the meter itself. That was not billed because of incorrect meter reading taken. Meter perfectly shows, but the meter reader not showing.
Suppose meter reader for 10 months back. Suppose he took a meter reading of 2000. And the previous month then must have been much more than that.
Yes, my lord.
So when he recorded 2000, you mean to say it might have conjecturally might have been 20,000 also.
That has happened. That has happened.
So how did you get the difference? Because the previous amount would be more than the subsequent amount.
That's what I'm trying to make out your lordships. For the month of January, suppose I have found meter reader has recorded what in the bill. But we have to, company has to depend upon his workers.
Meter reader calculates the difference and gives that to you, or the current meter reading only?
Current meter reading, both are entirely wrong giving. He's giving the wrong
current meter reading as well as the last meter reading, both are wrong.
Entirely wrong given. But black sheeps are there. No, I'm not on that. But this is what the company is suffering because of this.
Maybe that may be correct.
But the actual meter, even that was by the subsequent payment of the bills, that's they're admitting. meter reading always proceeds.
When this was detected? When was
Well,
this?
it was detected in the month of June 2023.
June 2023, correct meter reading was taken. Very well.
Then your losses, that was May and June, the disputed bills, your
May,
losses
June,
is to
yes.
cost.
Yes.
That was billed the difference, entire difference of 28 months. Now, what your lordship passed your lordship's direction, that month breakup month wise. Month wise is difficult for us. We cannot. We
Total
can
period you can.
I can. And we can give divided it by 28 months. But we can, if you also ask me, give for May 2022 exact meter reading, I can't.
So exact units you can give.
Exact units. And that's we have given. That we have given. But exact
Which,
breakup.
how much unit was consumed in which month you cannot give now.
Exactly. That we cannot give. That's our clarification I'm asking. Well,
so the term exact was used to qualify what? Month, unit, and something else?
That's your lordship's.
Let's see your fair.
Breakup.
Breakup. Connecting that to the months. If you connect the breakup to the month, then
it's very difficult. That's your losses.
So
submitted.
you can give the exact units consumed.
Exactly.
Only
that's why your losses. Internal page 6 of your lordship's order, page 474. Kindly take your losses. These last 5 lines. The CSC Limited shall raise fresh bills indicating the exact breakup. Breakup always relatable to months.
Absolutely.
That's where
at an exact months. Since you can't give the months, therefore you can't give the breakup also. But exact units you have given.
Kindly what I have submitted in the other paragraph 8 I was reading to your lawsuits. After I have read the first 5 lines, then upon the order dated August 14, 20 being passed, while attempting to detect the exact consumption in respect of the said month, it could be found that it was indeed impossible. Probably I have placed it, your loss.
Yes.
I was in the paragraph 9.
No.
I was.
After
it was
impossible
respectfully
task.
submitted.
Yes, from there.
It is respectfully submitted that if a portion of the units of electricity consumed in a given month is missed to be recorded, the bill is raised in respect of only the portion of the units recorded, and such mistake persists for a considerable period of time, it would be impossible for the licensee to quantify the exact as to what number of units were consumed but not billed in the relevant months.
Okay. So you can say that 28 months, for a period of 28 months, these were the units, total number of units consumed. This much you can say.
Then your losses in the case it had. Since incorrect meter reading has continued for a period of 28 months, it is not possible for the applicant to provide the actual number of units consumed in a single given month, because the data lastly available at the end of the licensee would provide the total number of units consumed till the last month when the bill was lastly raised, and the total number of units consumed in the month for which the bill is about to be raised. It is the difference between the two which would show the unbilled units. While the applicant licensee was successful in deciphering the point of occurrence of mistake, that is to say the month when the incorrect meter reading was first taken, by analyzing the power of consumption pattern of the consumers and the number of units consumed in each of the said months in which incorrect meter readings were taken, could not and cannot be quantified for the reasons indicated in the preceding paragraphs of this application. It is respectfully submitted that in terms of the order dated August 14, 2023, passed by this Honorable Court, the applicant revisited the bills raised and found for the months mentioned in the May and June 2023 bills that got quashed by the Honorable Court were correct. However, since the bill had been quashed, the applicant reworked the bills by applying the pro rata rule for raising the bills in respect of the unbilled units consumed, allowed the maximum slab benefit to the consumers, and therefore reissued the bills to them. The said bills were sizably lower amounts than the ones in the earlier bills by reason of providing slab benefits. The applicants demonstrate to proper slab had been given to the consumers that nobody has unjustifiably billed. Then paragraph 12 is important, my lord. It is respectfully submitted that in view of the peculiar facts and circumstances of the case, unless it is clarified by this honorable court that the expression exact breakup, exact months, and exact units consumed as employed in the order dated 14th August 2023 must be read to mean breakup, months, and units consumed to the extent possible and feasible. It is respectfully stated that it is an admitted position that the meter is not defective and has been registering correctly. It is also admitted that the units shown to have been consumed, registered by the meter as has been consumed, have been actually been consumed by the respective consumers. The aforesaid two admitted situations would cumulatively lead to the inescapable inference that the difference in demands payable in respect of the consumed units which have been billed thus far and of the total units consumed which should have been billed but have not been billed is the amount remaining unpaid in respect of the unbilled units. The quantum is payable by the consumers and receivable by the licensee. We raised bills, giving pro rata basis for 28 months. I must say, they immediately questioned before this court by filing the petition. We are coming, the clarification of this order that we cannot give month-wise.
Mr. Shana, please come back to para 9, page 15 once.
15.
Yes, sir. Because I'm not technical, I'm not a technical person. Please explain this portion, the last 6-7 lines. While the
applicant was successful in deciphering the point of occurrence of mistake.
That is the month when the incorrect reading was first taken.
But here your lawsuits.
Now then, you fudge the thing. By analyzing the power consumption pattern of the consumers, the number of units consumed in each of the said months. So how do you analyze the power consumption? Explain it to me in plain English.
I tell you lawsuits. Meter is not disputed.
Meter units, let us suppose not disputed.
Now what we have done here lawsuits, when we have got the difference.
How did you know the first month?
That's I'm taking a lawsuits. When we got the first total amount,
yes,
then we, my lord, went back to the billing process. That how it could be before that 28 months. It tallies with the before 28 months and the period.
So therefore the month beyond the 28th month backward, that month's consumption tallies with the current one.
Current month and current month we have taken your losses about 8 months before. Say your losses 400 units were the per year consumption. Now thereafter billing mistake, it get down to suppose 150. We are getting now total differential amount.
Go by the current one, back calculate and see. Suppose currently it's 400 average. So you go back to last when it was 400 average.
Exactly like that.
Acha, you have not stated here whether this person who took the incorrect readings, his employment, his period of engagement coincided with this 28 months. Was he in service for this 28 months?
Exactly. That's why we have said the new meter reader appointed. When
No.
In May, June 20.
Now means after these 28 months.
Exactly. When we deciphered.
So the first month out of these 28 months, did he join then? He was
there.
not there previously when there were higher readings?
No.
He was there only for these 28 months.
Exactly, if your losses tell me
It's not there in your application.
That's your losses.
Because we have to also correlate this incorrect meter reader with the period. Suppose we find he was also there when the higher readings were there. Then your only test is the higher meter readings.
May I give a crude example? I may be honest today, but tomorrow I may not be honest. It's not can be a loss. I may be honest today before losses.
But then tomorrow then go by only the higher consumptions, only that.
All are recorded. But this, my lord, amount consumed recorded. My learned friend can say so many things. But exact calculation is very difficult.
So the exact units which was consumed over this period is recorded. So your basis cannot be wrong, you are saying. That cannot be faulted.
Your losses may tell me I am wrong, month-wise calculation. I may be wrong.
Month-wise we understand the difficulty.
Yes, this is the situation.
So we have two variables. One is unit, number of units, and one is the total period. These are correct.
So your losses, we are in difficulty because of the expression exact backup of the. Now I tell you losses, they have taken 2 points over here. 1 point your losses, 56 applies retrospectively. This is probably not the, they have in the judgment, they have submissions recorded. Now after the judgment of, what a name, Prem Cortex, this cannot be.
56 applies retrospectively.
This says, point is that, 56 to that.
Justice Bhanumati, whose judgment?
Current Prem Cortex and Uttar Haryana.
Do you have an extra copy of the Electricity Act? Because now I currently don't take up Electricity Act.
In one matter, I also lost before your losses on similar situation. This is another judgment I will show Prabhu Pali. This happens.
Act. Electricity Act আছে আমাদের কাছে?
56 to 2 এখানে বার কর। 15 Electricity Act থাকা কথা। 56 to
Land কি রেজিস্টার?
Section 56 of the Act, Malan.
Yes.
May I read out it, Lords?
Yes, yes.
Subsection 1. Where any person neglects to pay any charge for electricity for any sum other than a charge for electricity due from him to a licensee or the generating company in respect of supply, transmission or distribution or wheeling of electricity to him, the licensee or the generating company may, after giving not less than 15 clear days notice in writing to such person and without prejudice to his rights to recover such charge or other sum by suit, cut off the supply of electricity, and for that purpose cut or disconnect any electric supply line or other works being the property of such licensee or the generating company through which electricity may have been supplied and transmitted or distributed or wheeled, and may discontinue the supply until such charge or other sum, together with any expenses incurred by him in cutting off and reconnecting the supply, are paid, but no longer, provided the supply of electricity shall not be cut off if such person deposits under protest an amount equal to the sum claimed from him, or B, the electricity charges due from him for each month calculated on the basis of average charge for electricity.
Did I hold that section 56?
No, your lordship had not.
I had
Probably because on this application they will raise it. Because I get an
No, they cannot ask for a rehearing on your application. They have not sought for, they have not challenged this order.
No, they have not. But I have come up for clarification. They made one submissions. The 56 to do not permit. Your lordship did not return any finding on that. But if I want to go back exact, they will raise it. That's why I'm taking silk.
Permitted you to raise bills for that period with exact disclosure.
Exact. Then, my lord.
Oh, yes. There is an observation that we cannot ascertain whether 56 is applicable because you have not disclosed.
That's probably they will come up. I'm said. Right?
So not they will come up. It's inbuilt in my order.
Yes. Now, your lordship.
Observe somewhere there.
The electricity charges due from him for each month calculated on the basis of average charge for electricity paid by him during the preceding 6 months, whichever is late, pending disposal of any dispute by him and the licensee. Malad, so far, so long, Malad is all right.
So good, yes.
Then your loss is 2. No. Joseph to manin na.
I'll cut off the electricity. Stop here.
But every day I was outside. And then I went because of 3:30. Because I tell you, I intended to tell your lordships.
That's why I did not dismiss the matter.
No, that's I tell you also why. Malad, I am personally, if you ask me, I am dead against of it. I used
Everybody
to
says that.
No. So I used to appear.
I'm not dead against anything.
No, I dead against. Malad, why 3:30? My learned friend will do with the matter. Malad, one matter I wanted to do.
Besides, do the matter, then I hear it.
No, that's one of your losses. After 2 days.
Is my duty is to sit throughout the day. So I'll sit.
But our resolution, I violated it.
Both of you don't appear, then I won't take up the matter.
That's not the proper thing.
But I give you a last opportunity.
No, what happens? No, I suffered your losses in this situation. I wanted a writ petition motion before Justice Dr. Dipankar Datta. He said, even after being satisfied, Mr. Shanna, look, Other side is not there today 3:30.
Justice Dotto.
Even that Dotto. Then I just told the Justice Dotto, look,
Justice
you-
Dotto has changed colors now. Volta-face.
No.
Volta-face. He's very vociferous about this, about our court being
That's-
lagging behind other courts on this.
no,
And I'm
Justice
saying,
Dotto in this court also against this.
can you
But
repeat
your
it,
lordship,
please?
my point is that
Can I have a video recording of this? Can I
yes,
make
yes,
this video?
yes, your lordship, yes.
I'll use it.
But then your lordship refused to do the folk knowledge. I'm conscious about it. His lordship did not pass the interim order ex parte because 3:30. I'm wondering what is the use of doing this?
Exactly.
One say you say 3:30 and if interim order will not. Unnecessarily, why should I go and quarrel with the honorable judge because I have to do the other matters?
Yes,
I
understand
did it
that
and came
now.
out. So this is the
That's what I
situation.
understand now. Whatever you would like. If you don't want to continue,
Then let us come on the next day, lordship. Then everybody wants. I will be placing on.
Heard in court. This is a matter for further hearing on September 11, 2020. September 11, 2020.
September 11.
4th is a holiday.
Much. 4th is all.
চলে এসছে